Violate the court's order, but I don't know.
Well, hello everyone, and welcome back to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court.
Informed him
and I
of
hope
this
today
information?
is the day
Does
we
that
earn that
person potentially
subscription.
have
I
other
am
people
back
who
from
could-
my power
other people
nap
know that he has
and
jury
feeling
duty and they
power
might be in the
rested
courtroom
and ready to
texting him.
go.
So, for example,
I am
a
happy
number of
to
just
be
citizen
here
members
with
in the
you,
gallery. Maybe
and
someone
I hope you're
in
happy
the
to be
gallery
here
also
with
knows
me.
this juror and then
We
sent
are
a
turning back
message
into
to a friend
the
of
Taylor
theirs or
Schabusiness
something
Trial.
like that. So
And
what
learning
you're,
more
I think,
about
the
the
individual juror
wonders
to
and
know
mysteries
what
and
was
enigma
shared, how it was shared,
that
by
is
whom it
Taylor
was shared,
Schabusiness,
might
the
give us a better
Schabusiness
idea
that
of
we
how
all
the
need
information
in
is
our
coming
life.
in and going out from the jury.
What the business, what the
Before I turn
business,
to
what
Mr.
the
Frelick,
business.
your comments have raised a
Schabusiness
few other pieces of information.
is
First
the
of all,
answer.
my understanding is in the
Daryl
conversation
Brooks
that occurred between
was
the judicial
looking
assistant and the juror,
for
there were other
Taylor
jurors
all this
nearby,
time.
and they heard that that might be happening. And
It is a shame
so
they were
I
unable
think
to
there
meet
may
up.
need to be,
Perhaps somehow,
some
some
kind
way,
of statement made to the
they will
jury
meet
as
in
a whole.
prison, which seems exceptionally unlikely.
To some of your other points, we also
But,
considered the fact that
You know, maybe
it could have
somehow
been
they'll
a
be
member of
transferred to the
public
same
who was using
prison,
their cell phone.
which is apparently a co-ed prison in this
I've asked security to
hypothetical.
look at the security cameras
But,
to
you
see
know,
if they can track down if that's
Who
the
can
case.
keep love apart?
I don't have any feedback from that search yet. But what I can tell you is my understanding is that the juror indicated the feed came across YouTube. Anything can come across YouTube. But the feed is, my order is very specific. There are 3 cameras in this courtroom, and there's to be no other cameras. So unless YouTube picked up on a video that was illicitly obtained and then posted it, I doubt that that's the source of the concern. The concern, of course, then is potentially false information's coming in to the jury. In any event, the state is suggesting that I voir dire or we voir dire that juror. And I'm going to turn to you, Mr. Frelick.
Thank you, Your Honor. All of this raises a question, I believe, of whether my client, Taylor Schabusiness, can get a fair and impartial jury.
I bet you would go there.
The jurors that we have. It's concerning. I know that my client has some concerns about this. I'd ask the court to consider a motion for mistrial.
Well, what I can tell you is I anticipated this kind of an argument. In other words, I know I denied a motion for change of venue or to bring in an outside jury. I'm absolutely convinced that there's nothing about this event that couldn't occur in any other jury situation, including had I brought in a jury from the opposite side of the state and sequestered them the entire time. So that is, everyone has cell phones that they have. Everyone gets text messages. And I expect the jurors are going to follow my instruction, which is, if someone tries to talk to you about this case, despite your telling them not to, you should report that to me. So the implication in there is you're not prohibited from receiving a text message from a friend about this trial. What you are prohibited from doing is discussing the case, and that your first step is tell them to stop doing that. And if they continue to do that, they're to report that to me. So I'm not going to grant your motion for mistrial because quite honestly, the issue is the same. We need a fair and impartial jury. All these jurors during voir dire have indicated we can do that. This is I'm not even sure if there's been an infraction because quite frankly, if this juror tells us, I got that text message and I said, don't talk to me anymore about this case, and then he reported it to the bailiff, that'd be precisely what I would want him to do. The problem is it spun a little bit, and it was, frankly, it was investigated, so we actually have more information than we did before. But I'm going to deny the motion for mistrial because I frankly don't see the basis for it at this point. But I think I'm going to avail myself of the opportunity to bring the juror in. Either of you want to either side want to hear from either the bailiff or my judicial assistant about the steps they took or the things they heard. Mr. Saunders?
I think what I'd be interested in knowing is to the extent that the judicial assistant or the bailiff is aware that other jurors partook in this process or were aware of this process, that's the information I'd be concerned about from either the bailiff or the judicial assistant.
Let me just indicate, again, I've spoken to both of them. My judicial assistant here is here. I'm going to recite what, because she's not near a microphone, but I'm going to ask her to indicate whether I'm reciting accurately. My understanding is when the juror shared this with her, there were jurors sitting there nearby who said, "Are we on TV?" And they were assured that they're not. Is that accurate, Ms. Pigeon? Okay. She indicates, because she's not near a microphone, she told them not to worry, they would not be on any video, which I think, frankly, was an accurate recitation, because from my understanding is they haven't been on, that my order has been followed precisely by the media, which is what I'd expect them to do. Anything else, Mr. Lezay, from either of the two, the bailiff or my JA?
No, Your Honor.
Mr. Freilich?
No, Your Honor, thank you.
Okay. I'm going to excuse my JA. She can go back and take up her tasks. But I am going to ask if you could invite that juror in to please bring him in. Actually, before we do that, I would expect we would just bring the juror right in here. Is there a request that we do it some other place? I don't know why this would be an inappropriate venue as long as they're not video. Mr. Saunders?
No, that's fine.
Mr. Freilich?
Your Honor, at least for me, I find this kind of to be a little unusual, and I'm concerned that if the juror has to answer some questions in front of a large crowd, it may be more uncomfortable, whereas if we're in a more private space with the lawyers in the court, the judge, might be a little easier.
Well, I've indicated to the jurors, and they've taken an oath to follow the law, to uphold their oath as a juror. I don't think I've noticed anybody on that jury who seems disinterested or unconcerned or upset in any way about what they're doing. They all seem very intent and very interested in serving in their role. So I'm satisfied that if I brought him in here, they'd answer this individual would answer the questions appropriately. And then once, so I'm going to bring the juror in here. After the juror is done, then we'll need to talk briefly about whether or not, and I'm inclined to indicate to all the jurors the circumstance, but we can also determine once we've questioned this juror the extent of the issue involved. So we're going to bring the juror in now, right here. All rise for the juror.
Fair enough. Yeah, so we have a potential issue with a juror. We're going to ask the juror some questions and just clarify what's going on. You know? Clear that right up. That's fine. You know, the juror received some sort of message, some sort of video, something. There was something that happened. Why not just ask it from the horse's mouth? Bring in the one juror, ask him, see what's going on. Very methodical, easy peasy, paint by numbers.
No.
Yeah, just see what's going on. Just see what's going on with this juror. Find out what the issue is and press on with our lives.
You have a seat right there in that first chair, sir. Thank you. So the reason you're in here is because we are responding to a concern that you had raised earlier this morning with the bailiff, I think, regarding potentially having been videoed while you're serving on the jury. And I'm really interested in knowing what you heard because we're trying to get to the bottom of the issue.
Sure. And it was a conversation I wasn't concerned, but so yesterday afternoon, a coworker of mine who works in Indiana, we work remotely, texted me that he had seen me at this trial, and I thought that was didn't think very much of it, and so then this morning when it was brought up, I had asked him where he had seen it, and he had said YouTube,
Okay.
and said that it was streaming.
Okay. And when did he indicate, maybe you said that, what time?
He texted me yesterday at 3 o'clock sharp.
Okay. Okay. Questions from the state?
Just curious whether he texted you a screenshot or a link, or was it just a text?
Mr. Freilich, any questions?
Did you save the text?
It's on my phone. Yeah.
So it's on your phone?
Yes,
Did you respond back?
I did.
Okay.
Thank you.
Okay.
Thank you.
Yeah. All right. Anything else that you feel you want to tell me about that event or issue?
No, other than you're free to look at my phone. I'm happy to show it to you. I'm happy to inquire further with him. I consider him a friend as well as a coworker. Whatever would please the court.
Okay. I am going to just indicate to you that perhaps, going forward, if you receive any messages from coworkers or friends, that you advise them you can't speak about this case at all until it's concluded.
Sure.
Okay?
Certainly. And my response was, thank you. That's what I said. I can show you.
Okay. Very good. Okay. I think I'm going to excuse you then. Thank you. All rise.
Okay, so we received a message from a friend. The friend says, I think I saw a video of you, and okay. The juror brought to the
Be seated.
bailiff's attention. Sounds like the juror handled it fine. So, seems okay to me.
Mr. Lizette.
Your Honor, I guess I don't have any concerns about how this impacts the integrity of the jury in any way. It seems like a very limited conversation. I think it is probably a good idea for the court to reiterate to the jury that you have given instructions that they aren't being filmed, just to potentially alleviate any concerns that they might have, and that you're confident that those orders are going to be followed.
Mr. Freilich?
Your Honor, I inquire, how is it possible that a juror in a case like this, or any case, is seen on TV? And that's concerning to me. I believe that, this juror, even by responding back, which he shouldn't have done,
To say thank you, get bent.
causes an issue for the defense, at least for the integrity of the jury.
No.
My client and I are concerned about, this jury, can it be fair and impartial?
No.
So again, based on what's been discussed here, make a motion for mistrial.
I'm sure you do.
I'm gonna
I'm sure
deny
you
your
really
motion
do.
for
Yeah,
mistrial.
mistrial, yeah.
I,
The juror said
a
thank
couple of
you.
things. First of all, I
Wow.
agree that the juror shouldn't have replied. First of all, the juror also indicated that he's not really concerned about it. And I think, one of the main reasons that we enter orders that jurors are not to be videoed is so that there's, for juror security. So
The juror's like,
This
I'm happy to show you the
individual
phone.
apparently wasn't concerned
Happy to
with
text
that
the guy, ask you
information.
for more. Just
Secondly,
whatever the court wants.
I'm not even certain that it
Wow.
happened. It's hard to drill into why he would get a video from, or a message from a friend in Indiana about being on this case, and if he wasn't, I can't explain it, but I'm satisfied that
This isn't that other
that
case
the
where Court
cameras
TV was
over
showing the
which,
jury
the-
every
the-
5 seconds.
I have control in this courtroom, that being the media cameras, aren't filming the jury. It's possible, I suppose, that someone in the audience used their phone to make that video. I don't have the results of the efforts by security to try to track that down. hopefully I will get something. But I'm not satisfied.
If someone
that
in the
this
courtroom
juror
film the
has
jury,
indicated in any way that
someone
this
in
is
the
going to make
courtroom
it more
better get
difficult
themselves
for
a
him to
lawyer
serve on this
right
jury.
quick.
He indicated he wasn't concerned.
There's your
So
legal
I'm going
tip
to
for
deny
the
the
day.
motion for mistrial.
Have you recently taken a
I
video
intend
from a
to
courtroom
just
of a jury
indicate-
in
I
process?
intend,
If
frankly,
so,
to,
you might want
do
to
two
call a
things.
lawyer.
I'm going to, again, read the
Right quick.
jurors the instruction that I've been giving them regarding communication. I think it's important to reiterate that for them. I'm also going to advise them that I've made a specific order that they're not to be videoed, and that from my investigation, as a result of this issue, that they haven't been videoed. As part of that, I think I'm going to need to relate to them that a concern has been raised, only because beyond that, they'll wonder, why are you telling us all this? But that's what I intend to relate to them. Mr. Lezay, any objection to that? No. Mr. Freilich?
No, Your Honor, but I have a concern.
Okay.
So would the court consider striking that particular juror? Because we have alternates. The other thing I'm worried about is there going to be discussion about, well, why did the court want to talk to you, to this male juror? I have some concerns about that as well. So would the court, consider maybe striking this juror? We've got several alternates.
Sure. Well, first of all, regarding a conversation the jury might have about why did the court want to talk to you, that's why I indicated I would tell them that a concern has been raised. And they'll get it, oh, it was the guy you brought out here. So, and I don't think the jury will in any way look on him disfavorably, because he was simply reporting to the court something that occurred, which is what I want people to do. So that's that. But let me turn to the state. Mr. Freilich has asked that I strike that juror.
And I don't think there's a basis to do that at this time based on the nature of the one.
There is not. There's not a basis to strike the juror. There's not.
I don't
fine.
either. I frankly think this juror has perhaps skirted a little close to my rule. Instead of responding thank you or asking when it occurred, he should have said something along the lines of thank you, but please don't talk to me on this until this trial is over. On the other hand, friends might feel that's a bit terse to reply, but I'm going to reinforce that. I think the point is
I think
that
thank
the
you's fine,
reply
Your
that he
Honor.
made
It's fine.
was so innocuous that I'm not satisfied he violated my order to the point where he would have to be excused. Again, I think
If all the juror
notion
responded back
that
with
nobody
thank you,
on this jury is going to get any text messages from anybody
yeah.
while this trial is
It's
pending is
fine.
something I simply can't control. So I can't find that in any way would cause me to strike him. And again, he's indicated he wasn't concerned with being shown as a juror, so he hasn't formulated
The judge is like, that skirts a
any
little
sort of
close to the line. I'm like,
bias or
I'm not sure it
prejudice As
does.
a result of that event,
It's like, I
He's
can't
just simply
discuss the
reporting
case.
What happened, which is what I expect a juror to do. So I'm going to deny the motion. Your motion is noted, Mr. Freilich. I'm going to deny the motion to
The
strike.
Court of Appeals will not care.
And that's what I intend to do.
Thank
Court-
you.
It's good. The judge is fine. It's fine. It's all good.
Anything else, Mr. Lezay?
No, Your Honor.
Well, Your Honor, have I mentioned the word mistrial recently? Because I'm not sure if I mentioned it. Maybe Your Honor didn't hear me before when I said the word mistrial. Have you thought about a mistrial, maybe, since the last time I asked?
Be seated. Welcome back, ladies and gentlemen of the jury. and I need to take up an issue with you before we get started. A concern has been raised by one of your number that perhaps at some point in time, perhaps yesterday, that the jury may have been videotaped and put out on a live stream. And a couple of things I want to advise you about that situation. First of all, I appreciate the fact that that it was reported right to the bailiff, and that's what I need you to do. As a result of the report, the matter has been looked into by scouring the videos that have been taken of this trial, and at no point in the videos that I have authorized to be taken have you been videoed. Just to give you a little more detail about that. In this trial, I've allowed 3 cameras to be utilized. Those cameras are situated in such a location that you're not being videoed by them. When I need to, I look at the media room and I can stop the video feed at any particular time for a particular witness. Perhaps you've seen me do that and heard me do that. I've entered an order that no one in the audience is allowed to use a cell phone to take photos or videos. At this time, security is scouring the videos of this entire trial to see if anybody in the audience has
In the unlikely
been
event
doing
that
it.
security
I
is
can tell you
watching
that I
the
can see
Unsettled
everything
Law
from up
feed.
here and I haven't noticed it.
Hope you all are doing
And in
great
case
over
you
there.
wonder, this courtroom is also being monitored in various different locations. So we're being
Also, in the
watched
unlikely
while we're
event
being
that the
watched,
court
okay?
security is watching this feed, may I kindly
People
suggest that you guys hit
are
that subscribe
videoing it Are
button.
being watched by the people that are sitting in the security
We
box
appreciate your
upstairs.
support.
So I want to assure you, that order was entered by me. I'm endeavoring to great lengths to make sure it's abided by. And as far as I know, right up until this very minute, my orders have been followed to a T. It doesn't mean I'll stop looking into it. And I would encourage any of you, if you have a concern about that, as we go forward, report it to the bailiff. There's one other thing I want to do, because it's important. I'm going to again give you this instruction. You've heard it before and you'll hear it again. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use computer, cell phone, or other electronic device with communication capabilities to share any information about this case. For example, do not communicate by blog, email, text message, Twitter, or in any other way on or off the computer. Do not permit anyone to communicate with you about this case. And if anyone does so despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based upon the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decisions in this case. After this trial is completed, you are free to communicate with anyone in any manner.
I kind of like this judge's demeanor. He has a very
That's all I'm going to have to
calm,
say about that for
reassuring,
right now.
and friendly demeanor. I think, I kind of like this
Case is
judge's
still with the
style.
state. Actually, we're at cross-examination, however. Detective, I think you were on the witness stand. I'll have you come back.
This judge has a
And I will
very
just
kind
remind you, Detective, you're
demeanor
still
to
under
him.
oath.
Judge handled it perfectly.
I'm also going
Judge
to
handled
remind
it
everyone
perfectly.
to please use their microphone. As you can see, we've switched court reporters. We are now using the DAR system, which is an excellent electronic system, but I want to make sure everybody's using their microphones. Having said that, Mr. Freilich, you've got a few complaints, so try to tend to your microphone, but I'm probably the worst offender. So go ahead.
Thank you, Your Honor. Detective Groff, good afternoon.
Good afternoon.
So on February 23rd of 2022, were you called down to the police department?
Yes,
What time did you get there?
I probably arrived about 4:45 in the morning, I think.
Okay, is that kind of a normal shift for you, sir?
All right, guys,
No.
I need to go off video for just
What's
a
a
couple
normal
minutes
shift?
because I need to prep my
7
chili,
a.m. to 3:30
so they'll be
p.m.
ready for dinner.
And why were you
I'll be back in about
contacted to get down there at 4:45
5 or 6
a.m.
minutes or so. Shouldn't take
As
too
far as
long
my
to put
duties
it all in
as
the pot
a
and get it started.
detective,
I'll see you guys
we
in a
can
minute.
get called after
All right, talk to
hours
you
for
soon.
major crimes, and in this case, I was called by a supervisor to ask if I would assist in a homicide investigation.
And were you told that there was a minivan that was found parked at the Eastman Avenue apartment complex?
Initially, my initial phone call, no.
Okay. At some point, then you were told that there was a minivan that was of interest, correct?
Yes,
And that was parked over at the Eastman Avenue apartments?
yes,
You interviewed several people, correct?
yes,
One being Tara Pakinich, correct?
correct.
And did you also talk to Stephen Hendricks?
No,
Okay. Did you talk to Taylor Schabusiness as well?
yes,
You talked to Ms. Pakinich and Ms. Schabusiness on the same day, fair?
yes,
Did you talk to Ms. Pakinich first?
yes,
And was it such that they were down at the police department when you arrived?
no.
Okay. You got there first?
I don't recall if I got there first or if Miss Pakinich was there first, but Miss Schabusiness was not there when I first arrived.
Okay. So you took Tara Pakinich into a room, correct?
Yes,
And what did you talk about? The fact that she found something in a bucket in the basement of her house?
yes, of course.
And you followed up with further questions with regards to that?
Yes, I did some preliminary questions, yes.
And did she indicate to you that Taylor Schabusiness and her son were friends?
Yes,
That they went to school together?
yes,
They went to high school together at Bayport?
yes,
And did she indicate to you that how she came upon the bucket in the basement?
Judge, I'm not concerned any of this is particularly prejudicial, but it is all hearsay. Ms. Package testified, and he can and did ask these questions to Ms. Package. The statement that the detective took from a witness who is not a party is hearsay information.
Well, it's really not offered for the truth of the matter, Your Honor. It's just to get some background information. But I can move on.
When you move on, so
Okay.
the question's withdrawn.
So after you finished talking to Tara Pakinich, then was Taylor Schabusiness brought in?
yes,
Okay. And initially, you introduced yourself, correct?
yes,
And Detective Kemp was there. Is that fair?
that's correct.
Were you sort of the lead detective on this?
Well, initially I was one of many detectives who came in to do the initial investigation, but throughout the course of the investigation, it took a more of a lead role.
Okay. So in the interview room, you swabbed her hands, correct?
Yes,
Did you take any pictures?
I did not.
You offered her some water, correct?
At some point, yes,
And then you told her that a few hours ago, officers went to a residence on Stony Brook Lane and a bucket was found with a human head in it, correct?
correct.
And what was her response, do you remember?
Something to the fact of, oh, really, or something to that.
Did she say that it's pretty effed up,
Yes, that would be correct.
pretty fucked up, correct? That's what she said?
Yes,
And did she indicate to you that Shad was her ex-boyfriend?
eventually, yes,
And then did you confirm that she lived on Eastman Avenue,
yes,
apartment 1 at 2353 Eastman Avenue, correct?
correct,
And she indicated that she lived there with a Scott Tomes.
correct.
And then you had further questions, correct?
Of course,
You asked her questions about things that may be in the basement, is that fair?
yes,
And did she give you comments like, well, that's a good question?
that sounds familiar, yes,
Did she say that she blacked out at some point?
yes,
And did she tell you that she needed time to think?
yes,
And you said, that's not a problem, take your time, correct?
that's correct.
When you were talking to her, was she smiling inappropriately?
I did not observe that, no.
Did you hear her laugh sometimes during the interview?
I believe so.
Her mood, did it kind of go up and down during your interview with her on March 23rd?
No.
Now, there were 2 detectives in the interview room with her, correct?
Correct.
And was there any sort of intimidation towards her at all?
Nothing.
During the time that you talked with her, did she say things that were sort of bizarre?
Well, some of the acts that she described that she did, were something that, was not common. But bizarre, I wouldn't say bizarre.
Unusual? How about that?
Sure.
Okay. And you told her that this was kind of an ongoing investigation, and the detectives and the officers and the law enforcement personnel on the scene were trying to figure out what was going on. Is that fair?
Yes.
Because law enforcement really didn't know what was going on, correct?
Absolutely not.
It was, would you say it was a situation that was unfolding and developing?
Yes.
She did indicate to you that, did she exhibit responses that were kind of short and snippy?
No.
Did she say that she did not know what was going on?
Well, she did make a comment that at one point she had blacked out, and again, I assured her that she could take her time, and she had plenty of time to remember what she did.
Now, you've been on the force you've been an officer for 27 years, correct? You've got a lot of experience, is that fair?
37 years.
37 years, oh, sorry.
I'm sorry, 30 years, and yes.
30 years, okay. So, and you've been a detective for 17, yes?
Yes,
You've worked with people that have used meth, correct?
I have.
Meth is a very powerful drug, isn't it?
It can be, yes.
It can cause people to act and react in an unusual way, is that fair?
Yes.
When you were talking to her, she had some problems answering questions, correct?
No.
She would mumble and trail off when you would ask her a question, is that fair?
No.
She said a few times, damn, my head. Didn't she say that during the interview?
I don't know if she's referring to her head or Mr. Thyrion's head.
Okay. You didn't know what she was talking about, correct? On that topic?
I don't recall.
Okay. Did she tell you that she was coming off a high or a buzz?
No.
She did say that she was paranoid, correct?
She did mention the word paranoid in terms of why she had left the residence.
And she said it was really weird. She made that comment, correct?
I don't recall.
And she said, I think it was the dope. Didn't she say that to you?
She did make those comments, yes.
As far as the investigation was concerned, there were no human remains found at the Eastman Avenue apartment. Is that fair?
Correct. Not inside the apartment.
Correct. There was a minivan, well, strike that. At the apartment, Scott Tomes lived there, correct?
Yes.
And he also owned a gold-colored Town and Country minivan, correct?
Correct.
When you were talking to Ms. Schabusiness, she did say something about she heard gunshots, correct?
Correct.
Did you hear any gunshots
When?
when you were either at Stony Brook or at Eastman Avenue?
I was never at Eastman, but when I was at Stonebrook very briefly, it was much later in the day, and I did not hear any gunshots.
You reviewed a lot of different reports and talked to a lot of different detectives, including Detective Scanlon, Detective Kemp, Lieutenant Buckman, a lot of the other officers involved, correct?
Yes.
Did any of the officers provide any details or reports about any gunshots being fired at either Stony Brook or Eastman Avenue on or about February 23rd of 2022?
I don't recall who said, but I do recall that during the time that officers were called to the Stony Brook residence, that there was another call that officers were on that might have involved gunshots.
At some other location, though, correct?
I'm sorry?
At some other location, not Stony Brook or Eastman Avenue, correct?
Correct.
During the interview that you had with Taylor Schabusiness, did it go on for about 6 hours?
That's an estimate on my part. I'm not sure.
That's fair. That's fair. So you started in the morning, and then at some point you took a break because she had to go over to St. Vincent's Hospital,
Yes.
and then you came back and then resumed the interview, correct?
Yes.
All at the Green Bay Police Department?
Yes.
You had a chance to look at her hands, her thumbs, and her fingers, correct?
Yes.
She had some scratches and some deep cuts on her thumbs and fingers, is that fair?
She had a cut on her thumb and some scratches. Yes.
And she got medical treatment for that?
Yes.
Were there, when you asked Ms. Schabusiness some questions, sometimes she was non-responsive, is that fair?
No.
She did not answer your question every time you asked one, is that fair?
I would not say that is correct.
She said some odd or weird things, though, correct? During the interview? Specifically, well, the arm or something like that would rebuild into muscle?
Well, yes, she made several comments of, when she was strangling Mr. Thyrion that, his muscle would rebuild, and made several comments about, that she forgot to leave, or she forgot to leave the head behind in the bucket in the basement. Those types of comments in terms of describing her actions and what she was doing. But in terms of those being bizarre, I did not find that to be in any way, shape, or form.
You found it to be odd, though, especially when she laughed about it, correct?
Well, I did not feel that way.
But she did laugh about it when you talked about it, correct?
I think maybe at one point there was kind of a smirk or something, but it was in the context of just how she replied back to me.
And she did tell you that on some date before February 23rd of 2022 that her and Mr. Thyrion were smoking ice, correct?
Smoking, yes. Ice,
She-
or
she-
methamphetamine,
Yeah. She used the word bitch, correct?
initially.
And then it changed from ice to methamphetamine, yes?
Yes.
And then she indicated that a meth pipe and a plastic bindle would be in the basement.
She said that.
She told you that it was a weird night, is that correct?
I'm sorry, can you repeat that?
Did she say that it was a weird night?
That's possible.
And then she did talk about drugs, and she talked about the fact that she's been off drugs, and then she's on drugs. She said words to that effect, is that right?
We did talk about her drug use in the days previous to the interview. I believe she did make comments of using drugs in the past. As term of her, how much, I don't recall that.
Okay. And fair to say that during the interview, oftentimes Ms. Schabusiness would say, I don't know. She didn't know the answer to your question?
I'm sure that she probably had some of those answers.
She would say, I have no idea, correct?
I guess I would have to know specifically what I was asking her.
And Is it fair to say that some of the things that she said just didn't make sense?
No.
You sort of had a narrative and she kind of went along with it, correct?
I would not say that, no. I did repeat several of things that she would say to clarify, but I would not say that I led her in any way.
When you were talking to her, oftentimes she'd have her hand over her mouth, correct?
It's possible.
And she would talk very softly, correct?
I was able to hear her.
But you did talk softly, correct?
I don't know.
She said something about that she was tweaking out or that she was tweaking. Do you know what she meant by that?
I do not recall those specific words. I would know what she would mean by tweaking out, though, yes. And I don't recall as to what time period she was talking about either.
Okay. Is it fair to say that the first part of your interview was about 3 hours and then you went to the hospital?
That's fair.
You came back and then the second part, was that about
All
3
right,
hours?
guys,
or how long
chili
was it?
is
I'm
on.
not sure.
Not sure. A couple hours though?
Sure.
Took a while to
Exciting.
ask questions and try to figure out what was going on. Fair?
Right. As I was interviewing her, there are investigators who were at the house, and so it was an ongoing and continuing investigation to determine what happened.
Right. During the interview that you had with her, she said, "I didn't mean for all this to happen. I'm sorry." Is that fair?
I think that she did make a comment as to initially that she did not mean
put it on
to,
slow cook mode.
kill Mr. Schabusiness. I'm sorry.
We'll be ready in
Mr.
5
Thyrion.
hours.
You had cases involving asphyxiation, correct?
Yes.
And can you tell me what we mean by that? Is it choking?
Asphyxiation.
Yes.
Choking is another word. Is when someone's windpipe or has been blocked and breathing has been obstructed.
Is it a situation where people that maybe are into this kind of
Crock
thing
pot, baby.
choke each other to get some euphoria
Instant
or
pot,
pleasure
but I
out
put
of
on
it?
slow cook mode, so we're using
I have heard of
crock
that
pot.
practice.
Yeah, we're following the Taylor Schabusiness cooking method
With regards to this case,
with the slow cooker.
law enforcement
Low and
did
slow,
find
baby.
two
Low and
dog collars
slow.
or two chains. Is that fair?
Yes.
During the interview, Ms. Schabusiness said something about, "I can't think right now." Remember that?
No.
She said, "I'm fucking nuts." Remember that?
No.
The crock pot and Instapot are awesome. I very much recommend an Instapot. Get the larger size though. I think
Were
mine's
you,
only 5 quart, and I really wish I had
surprised
the
by
7
some
quart
of the things
model.
that she said to you?
You get yourself the larger, spend the extra $20 and get yourself the larger version of the Instapot. It's fantastic. Highly recommended.
Overall, in the context
There's a
of
reason
what we were
that
discussing
it's so
and the
popular.
information
Kick
that
back.
had provided to me,
Yes.
no.
And did she tell you that the body can rebuild itself?
She made that comment, yes.
This stream brought to you by Instapot. Taylor Schabusiness was using an off-brand crock pot. Use only Instapot for all your cooking needs.
There was a second interview on February 28th of 2022 back at the Green Bay Police Department, correct?
Yes,
And Detective Scanlon was there for that.
he was.
Did he kind of ask most of the questions for that interview?
I think it was 50-50 in both our parts.
And did Ms. Schabusiness indicate to you or to Detective Scanlon that she was freaking out?
I do not recall those exact words. It's possible.
Okay. Do you recall, though, that she talked about having a lot of issues with open areas? You remember that?
But she was talking specifically about the basement area that she was in.
She didn't like the open area, though, correct?
No.
I'm correct on that?
I'm sorry?
I'm correct that she did not like the open area, is that right?
She didn't. not like
None of these
the
questions, by the
open
way, are not
area of the
stupid,
basement
in case
at
you were
Stony
wondering.
Brook.
None of these questions are not
in Green Bay.
stupid.
Thanks, that clears that up for me.
They're all stupid. We all heard the confession for ourselves. We all saw her behavior for ourselves. There's nothing that he's answering that we can't observe, by the way, or hear.
Her emotions came out during the interview, is that correct?
It's possible.
Did she tell you that she got very angry at herself?
Once again, it was quite a lengthy interview. I do not recall every single comment that she made.
I don't care about any of these things, even a little bit. These are all stupid.
She did say during the interview that
He's trying,
there
though.
were some times
I
where
mean,
she
I don't
nodded
blame him
out,
for
correct?
asking.
Yes,
because he has
I do
nothing
recall
to
that.
work with. He has nothing to work with.
And
Well,
she
what do you do
indicated to
when
you
have
that
something? It's roughly this.
her and Shad went
Not
in the
his fault he
basement,
doesn't have anything.
and within about 5 minutes, got to it, correct?
Got to it.
Yes.
She stated that Chad produced a couple chains. Yes.
Yeah. Within 5 minutes of being down there, correct?
Correct.
And she told you there was no kissing, correct?
I do not remember that at all.
And she told you there was no sex, correct?
She said that it was starting to lead that way, but there was no sex while
He didn't even get. He didn't
Shad
even
was
get to have
alive.
fun
There was
time
no
before the strangulation.
penis to vagina sexual intercourse going
That's
on,
just
correct?
wrong.
Is that fair?
penis to vagina, no.
Ladies, if you're
I'm
going to
correct about
strangle a
that,
man
right?
to death, at least let him have his.
She never stated
let him
that
have
that
sex
occurred.
first.
Okay.
That's just polite. I seem to remember reading that in like a Dear Abby column once, where Abby said that if you're going to strangle a guy, you got to make sure that you show him a good time first. Or maybe it was Miss Manners. It's hard to keep him straight sometimes.
And did she indicate that her and Shad Thyrion had took a toke off of some meth at the Eastman Avenue apartment in the bedroom?
Yes.
Okay, I have nothing further.
Correct.
Just very briefly, you were asked about a couple of terms, nodding out and tweaking. Are those terms that you have encountered in your experience as a detective or as a narcotics investigator?
Yes.
What do those terms mean to you, starting with nodding out?
Nodding out is a term typically heroin users would describe when they would become drowsy
As a result of the drug use?
as a result of the drug use.
And how about tweaking?
Tweaking it can refer to methamphetamine users. It's a stimulant, so it could cause them to be hyper or sudden body movements, and that is a result of the use of methamphetamine.
No further questions.
Anything on that, Mr. Fraley?
No.
Okay, thank you. You can step down. Does the state have any other witnesses?
No, Your Honor. At this time, the state rests.
Okay. Ladies and gentlemen, the state has now rested their case. We're going to take a brief recess, and we'll reconvene in about 10 minutes. All rise for the jury.
Would you like to move for a directed verdict right about now? Your Honor, I don't think the state has proven each of that every other case. They already proved that the defendant acted with intentionality and that they did the body, and I think they're real thin there on some of these images. I think a directed verdict of acquittal sounds good right about now, Your Honor.
All right, be seated. state has rested, then, Mr. Freilich, the case would then turn to the defense. Do you intend to call witnesses, or do you want to address me on the stipulated facts?
Yes, before I do that, Your Honor, I'd like to make a motion for a directed verdict.
Of course he does.
The court consider,
Use the microphone.
ask that the court consider that as it relates to the first-degree intentional homicide count, I would argue that there is insufficient evidence to support that particular charge. There's insufficient evidence to show that my client, Taylor Denise Schabusiness, had any intent to kill St. Shad Thyrion. What we have here is some testimony from a number of law enforcement officers. We also have some video footage from an interview between my client and Detective Groff and Detective Kempf. It's clear that my client likely did consume and ingest methamphetamine.
Right now, the
with
judge
Mr.
is going on Amazon.com and considering
Prior to his death,
gym equipment.
My client
If you
provided,
need Amazon equipment, you can
commentary
check out my Amazon link
and,
available from my link
answered
tree,
questions from Detective
where you can
Groff.
check out some cameras and microphones
Submit
that I
that
recommend.
what she indicated
for
that was
streaming.
that she had no intent to kill. The question is, did my client do it or not? That's another question. There are a lot of different issues here going on, but based on what she said,
This
to
is a
the
complicated case, a lot of different
detective,
ins and
I'd
outs.
ask that the court consider dismissal of the first-degree intentional homicide charge on the grounds that there was no intent to kill.
No.
Also, there are really no eyewitnesses to whatever went on in the basement at 829 Stony Brook Lane.
The judge is literally
in
just
Green
waiting
Bay.
for him to stop talking.
When Tara Pakinich and Stephen
Maybe if I
Hendricks
don't-
went
maybe if I
downstairs,
stop-
they
maybe if I
didn't
don't
find
stop
anybody down there. They
talking,
found body parts.
Then the judge can't
Unfortunately,
rule
they did not
against
find
me,
my
so I'll
client
just
there.
keep
My
talking.
client was at
Can I filibuster? Can I
2353
filibuster
Eastman Avenue.
a murder
And
trial?
that's where she was arrested.
Murder?
And there were no body parts over
I'd
there.
like to read a book.
There were body parts in a
Red
van
fish,
that was owned by
blue
Scott
fish,
Tomes.
one fish, two fish.
It's not my client's
It
minivan.
speaks to me
that
in
gold
this case,
Town
in
and
so many
Country
ways.
Chrysler minivan.
Referring to the
belonged
words
Mr.
of Dr.
Tomes.
Seuss.
So there are a lot of issues
One
here.
fish.
As to
Two fish.
the third-degree sexual assault
Is
charge,
it a problem with counting?
the state's got to prove that my client
Is
had
Dr.
sexual
Seuss unsure?
intercourse with
What
Shad
does he mean
Thyrion.
by fish?
I believe
What is
based
the
on this
nature of
record,
oneness?
there's, in the video, there's no
Are we
evidence
one
to
with the fish,
show
or
that my
are we-
client had any kind of
Is
penis to
the fish in
vagina
Dr. Seuss's
contact
book?
with
Maybe.
Mr. Thyrion. We have testimony
He's
from
one of the two fish. Of the
the DNA expert that indicated it was uninformative as to the dildo. And I know that my client claimed that the dildo was used on Mr. Thyrion, but there's no DNA evidence on that. And so I would ask that the court consider dismissal of the third-degree sexual assault charge as well for those reasons. Thank you. Finally, as to the mutilating a corpse, count two, again, there are no eyewitnesses to observe what really happened in the basement on the date in question. So for all these reasons, I'd ask that the court consider the motion for a directed verdict and dismiss these charges.
Mr. Saunders?
A reasonable juror viewing the evidence in the light most favorable to the state could convict. The state's met its burden. His motion should be denied.
Thank you.
Okay, well, these motions are fairly common in cases like this, and the court does have to, in these circumstances, look at the evidence in the light most favorable to the non-moving party. This is by no way the court making a decision about what the ultimate verdict in the case will be. That's up to the jury, not up to me. But the court's task at this point is to take a look at the four corners of the record, the evidence, to see whether the state has satisfied their burden of proof, at least to this point, such that the matter can move forward and be given to a jury. Each of these counts has two elements. The homicide count has two elements. mutilating a corpse count has 2 elements, and the third-degree sexual assault count also has 2 elements. And the court is satisfied when considering the entire record in this case that a reasonable jury could conclude that the state has met its burden and convict based upon the evidence that has been offered thus far. Again, I'm to look at the evidence in the light most favorable to the non-moving party. That isn't necessarily how a jury will look at it in their deliberations, but that's what I'm to do at this particular point. And in doing so, I'm satisfied that these motions for directed verdict should be denied, and that's what the court does at this time. So those motions are denied. And so I'm going to
Thank
turn
you.
it back to you, Mr. Freilich. My understanding is as a result of Mr. Tomes not being here due to some health issues, that there's been a set of stipulated facts.
Yes, Your Honor, but before I do that, I know that my investigator had made attempts to contact Scott Tomes as part of the defense investigation in this case, and my investigator was not successful in making contact. But we did get a subpoena out, and the Brown County Sheriff's Department, I believe, subpoenaed Scott Tomes for court as a defense witness. The prosecutors did inform me promptly that he is not going to be available. Maybe he's got health problems or hospitalized, but they told me that he is not available. I've advised my client of this. I find that, and I'm not blaming the state, but I'm blaming him, that the timing of this seems suspect to me, that he's not available. I haven't seen any report, doctor's note, anything like that. So before I answer the court's question, I'd ask that the court consider a motion for mistrial because this witness is not here, has been properly subpoenaed, and I really have no recourse to call him and question him about the issues in this case. So I'd ask that you consider that motion.
Well, before I turn to the state and ask for their response, Mr. Freilich, what can you tell me? What was your expectation of what he was going to testify to?
Well, I have some highlighted sections from his statement that the state and I agreed on as to what his testimony would be about. But, when you call a witness, there may be other things that come up. But I'm working off a statement. I've highlighted the yellow parts.
Yeah, but it's your
would be
witness, so
told to the
make
jury if
me an
the court
offer of proof.
Felt that was appropriate. But
Let's
I felt
try it that
the
way.
need,
Make me an offer
because
of
I'm
proof.
at this
What
kind
would
of
your witness
crossroads with
testify
this kind
to?
of problem, that I would make this motion first.
Okay, sure. But I don't think you have my question, because the question is, you've
Try
asked
it this
for
way.
a mistrial based upon the
Make me an
unavailability of
offer
this
of proof.
witness. So the question is, what was he going to testify to so that I can assess the gravity of his not being here?
I understand. Okay. Thank you. I believe that he would testify that on that Monday night, I believe that would have been February 21st of 2022, that that Mr. Thyrion and Ms. Schabusiness came over, that he did not know Shad's last name, but he saw him before, and that he believed that they hooked up to get some meth or do meth. That would have been about 9 p.m. on Monday night, and that he had this gold Chrysler Town and Country minivan, and his keys were on a lanyard which hangs on a hook by his front door, and that he indicated that Taylor Schabusiness has used his vehicle in the past, but with his permission, and that she's always asked to use it. And then he said she did not ask to use the vehicle last night, and that he did not give her permission to take the vehicle.
Well, that's what Taylor Schabusiness
He said he did not call the police to report the vehicle missing.
He said that.
And then he indicated that
Heard
he
it.
was drinking some whiskey and cranberry juice, and that he sometimes gets drunk, but not inebriated. He indicated around midnight, Ms. Schabusiness returned home with his vehicle, and she went basically directly to her bedroom, that he had a suspicion she may be high on drugs, and that he believed the police arrived 15 or 20 minutes after Ms. Schabusiness got home. And then he talked about the living arrangements in the apartment, and that
The judge is
Mr. Business
thinking
stays
about
in the
what he wants for
bedroom and
dinner right
sleeps in
about
his chair
now.
in the living room. So,
Okay, so the first thing I want to take up is Mr. Freilich's motion for a mistrial based upon the unavailability of Mr. Tomes.
I think the motion should be denied. Essentially, everything counsel stated, the state is willing and has prepared a stipulation to that effect. So obviously, I don't think that the drastic remedy
That
of
solves the
mistrial is
problem.
necessary. I do want to be quite clear.
Right.
The state does not control Mr. Tomes. We in no way told him to disregard a defense subpoena as part of our case. We chose not to call him. We were advised about the medical issue, and we passed that information along to defense counsel. So I don't want it to there be this record
We will
that
stipulate,
we are
stipulate to
influencing his
literally
unavailability
everything
in
that
any
you
way,
said the
or
witness
state
would say.
Counsel can still attempt to have him
End
here and
of
still
problem.
attempt to produce him. It's an issue the state deals with
We will
fairly
agree
regularly
the
in
witness
trials.
would have said all those things.
That isn't being done, so
All
I don't
those things
think
are fine.
The defense failing to produce a
We don't
defense
care.
witness is grounds
All
for
that's
a
great.
mistrial. Particularly when
Solves
the state's
the problem
going to
right up.
stipulate to everything the defense seeks to elicit, essentially.
Your Honor.
Wow,
I
what a
want to
deal.
let the court know that Mr.
What a deal.
Saunders promptly let me know of this situation as soon as he found out about it, so that was appreciated.
Okay, I don't want all the details, but as far as a medical issue, I mean, if you have a bad cold, that's a medical issue. If you are in the hospital for serious surgery, that's a medical issue too. Is he incapacitated? Is he just staying at home because he doesn't feel like getting out? Do we have a sense of that?
I think the latter. The information we received is that he was in hospital and would be for several weeks. That was the information we received from a relative.
Okay. Okay, well, so in front of me then is a motion for a mistrial. A number of things. First of all, when I listened to the recitation of the information that Mr. Tomes was going to testify to, first of all, I'm satisfied that a lot of that information has already been testified to by other witnesses.
I've heard a lot of that
particularly,
before.
the individual, the mutual friend of Mr. Thyrions and Ms. Schabusiness, who was here yesterday, testified to some of the events that occurred at Mr. Tomes' apartment. Frankly, some of the other information that Mr. Tomes was going to be testifying to that was referenced by Mr. Freilich, I think was brought in through some other of the witnesses. The information about what Ms. Schabusiness did with Mr. Thyrion while they were at Mr. Tomes' apartment. There was reference to potentially utilizing controlled substances there, that perhaps
Do they have any other
Mr.
witnesses other than this
Tomes
guy?
was
That's the one
in
question I want to
either
know.
a different
I-
part
I
of the house, or was
I'm suspicious
had
the
his,
answer
his
is no.
gaze focused somewhere else while they
I'm
utilized
suspicious
controlled
that
substances
the
behind his
defense
back,
has
so
no
he
other
didn't
witnesses
see.
except for this one guy.
That kind of information has
Let's
come
see
in
if I'm
other,
wrong.
in other areas.
Something in their tone
Really, the only
says
piece of
this was the
information
only witness
that,
I have. Might be
that I
reading too much
heard
into it. Let's find
that,
out.
that doesn't sound like it came in any other fashion, except by indirect statements from Ms. Schabusiness in her interview with law enforcement, was the comment that, when she used his van in the past, she asked permission, and that she didn't ask for permission that night
Your Honor, I'd like to call the methamphetamine to the
to
stand.
use his van. And there's a couple of things about that particular piece of information. I remember the information in the video where the detective was asking her questions, and she indicated in response to her question, I don't know if he knew that I was leaving.
Your Honor, I'd like to
I
announce
don't
my
know.
surprised
I
witness.
think she was
Cocaine.
uncertain whether Mr. Tomes actually knew that she was leaving. And the reality of it is, if she was
Your Honor,
utilizing
we
his
can't have
van
cocaine
and she
to
was
on his
uncertain
van.
whether or
They
not
haven't
she even
proven
knew about
themselves
it,
to be reliable.
whether or
Your
not
Honor,
he even
that's
knew about
simply
it.
a falsehood. We all know that
then
she can't
that
lie,
might
she can't
confirm
lie, she can't
a
lie.
statement
Cocaine.
whereby Mr. Tome says, yeah, she usually asked for permission, but that night she didn't. That would be very consistent with what she reported in her interview. Beyond that, I'm not really sure
Not sure if that
the
joke
extent
worked,
to which that piece
but
of
I tried.
information is so relevant, that his presence is needed here as opposed to stipulating to the facts that are outlined. Relevant, that his presence is needed here as opposed to stipulating to the facts that are outlined. For all those reasons, I'm satisfied that the fact that he hasn't responded and arrived here today due to medical reasons, I'm not going to grant a mistrial for that reason. I am then going to turn to the parties to determine if there's anything else that needs to be recited regarding that stipulated set of facts, or whether, Mr. Freilich, you've actually gone through and recited it there. Is that what you would intend to have recited?
Mr. Saunders has it, Your Honor, so I'm just going to take another look at it real quick.
I'm sure you did. Look at it real carefully. Look at it. It's my only piece of paper. It's my friend. My piece. Your Honor, there are many pieces of paper, but this one is mine. My piece of paper protects me, and I protect it. I will not abandon my piece of paper.
And what I did was highlighted in yellow the relevant sections from the statement he gave to police, and then Mr. Saunders' office had it typed out, so it's in proper order.
Okay. Gentlemen, how do you want that submitted into the record?
I can mark it, and then perhaps the court can just read it at some point during the defense case.
You want the court to read it?
Yes, please.
Okay. Sure. Well, then we'll mark it as Exhibit 111.
Do you have any other witnesses? Anyone at all?
Okay.
Would you like to call the bucket?
All right. So, then just for my own edification, Mr. Freilich, I would intend to read this to the jury as soon as they're brought back in.
Okay.
Other than potentially your client testifying, do you have any other witnesses that you, because then we're going to move right into other witnesses, but if you said, well, that's the only one, and then the only issue is whether your client's going to testify, then how we'll proceed is, I'll bring in the jury, I'll read in these stipulated facts, I'll excuse the jury again, and then I'll have the colloquy with your client about her testimony. So can you give me a sense, do you have other witnesses?
Your Honor, I've looked at my list here. A lot of the witnesses I was going to call have already been called, so I think we're good. I will need some additional time to confer with my client
Who knew?
on whether she wishes
I
to
knew
testify
it.
or not.
Uncivil
but,
called it.
that's where we're
Uncivil
at.
solid.
Right, well
Come
then,
in. I have no
just
other
quick,
witnesses.
I know
I
some of the
have
defense,
no case.
Some of the law
Uncivil
enforcement officers have defense subpoenas.
prediction.
Is it okay to cancel
Yes.
Yes, it is.
them? Thank you.
Okay, it sounds like all the other subpoenas that are out there are now canceled, okay?
Thank you.
Anything else before bringing in the jury, Mr. Saunders?
No.
Mr. Freilich?
No.
Okay, so I'll bring in the jury, folks. I'll read them this stipulated facts. I'm going to excuse them again. We'll break for a little more so you can speak with your client about testifying, and then we'll come back and I'll have that colloquy with her and go from there, okay?
Okay,
You think
thank
she's
very
nuts
much.
enough to take a stand? You think she's crazy enough to do it? You know, at this point, I honestly don't know what the right answer is. I mean, I only say that because the evidence against her is so incredibly damning. Right, her own statements in the court from the at the police station are so incredibly damning that at this point, I don't know. Maybe it's like, you know, I literally have nothing to lose at this point as the defense lawyer. I literally have nothing to lose. It can't possibly get any worse. Maybe I put my client on the stand and hope that somehow, some way, a miracle occurs. Is that an option? I'm going to advise my client to take the stand because I need a miracle.
Be seated.
All I need is a miracle. All I need is you. Taylor Schabusiness. All
Ladies
I
and
need
gentlemen of
is
the
a
jury, the state of
miracle.
Wisconsin,
All I
the attorney for the
need
defendant
is
and the
you
defendant have
to take the
stipulated or
stand.
agreed that if Scott Tomes had been called as a witness, he would have testified as follows. Scott Tomes was interviewed by a Green Bay Police Department detective on February 23, 2022, and stated that on Monday night the defendant had a friend over named Shad. Mr. Tomes did not know Shad's last name, but had seen him before. Mr. Tomes indicated he believed Ms. Schabusiness hooked up with Shad to get and do meth. He believed this was about 9 p.m. on Monday night. Mr. Tomes stated that he had his car keys on a lanyard which hangs on a hook next to the front door. Tomes stated his vehicle is a gold Chrysler Town & Country with Wisconsin tag 580ZJZ. Mr. Tomes stated Taylor has used his vehicle in the past, but with his permission, and that she always asked him to use it. She stated Ms. Schabusiness did not ask him to use his car last night and that he did not give her permission to take his vehicle. He did not report the vehicle missing. Mr. Tomes stated he was drinking last night and indicated he gets drunk but not inebriated. He indicated that around midnight, Taylor returned home with his vehicle. He stated she basically went directly into her bedroom. Mr. Tomes suspected Taylor was high on drugs. Mr. Tomes believed the police arrived 15 to 20 minutes after Taylor got home. Mr. Tomes was
This is the
also
greatest murder
asked
trial
about
ever,
the
man.
living
This is the
arrangements in his
greatest murder trial
apartment and
ever.
stated that
It's a
Taylor
3-day
stays
case.
in the bedroom
I love this.
and
I
he
love this
sleeps in
judge.
his
I love
chair
this
in the living
trial.
room.
We did an
Mr.
entire
Tomes was later
murder case in
interviewed
3
by a
days.
Green
It's
Bay
great.
Police Department
It
detective
doesn't have to
on
take 6
March
weeks.
9, 2022. Mr. Tomes stated that A.J. Gannon and Taylor Schabusiness were at the Eastman Avenue apartment on Monday, February 21, 2022, before they left and came back with Shad Thyrion. Mr. Tomes stated that Gannon did leave on his own, leaving Taylor and Shad still at the residence. You will consider that testimony in the same manner as if it had been given under oath here in court. I have marked that as Exhibit 111, and that's being offered, Mr. Freilich.
Yes, it is, Your Honor.
Exhibit 111 will be received.
Your Honor, could that be published to the jury? Or
Um,
probably not necessary, I
yeah,
guess.
I'm
I'll
not going to
withdraw
publish
that.
it to the jury because that would involve either putting it up on the screen or passing it through there, and I'm not going to have them read it. But it is Exhibit 111.
Thank you.
And then, ladies and gentlemen, I'm going to excuse you briefly again, so all rise for the jury.
What do you think is the odds that the Taylor Schabusiness takes the stand? Do it, 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 do it.
Be seated. Well, Mr. Freilich, my understanding is you'd like to speak with your client for a little bit about her decision as to whether or not to testify. Is that correct?
That's correct, whether she's going to testify or not testify.
My understanding is you can do that right back there to the side door. So we'll be in recess then. I'm going to be checking in on you, Mr. Freilich, by 25 after. But if you need a little more time than that, you need to let us know. But I'm going to check in with you about that time, okay?
Okay, can you just give me till 2:30, Your Honor?
Sure.
Okay.
2:30.
All right, thank
we're
you.
in recess.
Can I have 12 minutes, Your Honor? Sure. Do it, do it. I'm going to check with you at 25 past. Can I have till 2:30? It's so hilarious. This is so funny. You know. Yeah. So here's what's going on, Taylor. You're going down in a flaming pile of absolute destruction. You want to roll the dice and take the stand because hey, maybe you'll so charm the jury. You're just such a charming, affable, young, beautiful woman, And maybe if you just bat your eyes just the right way and play the doe-eyed innocent, those mean cops, mean cops tricked me. I would never do that to my poor baby boyfriend. I'm not the monster they make me out to be. Those mean cops. Let me do my best batting. Those mean cops. They tricked me. They took advantage of my innocent, doe-eyed belief in justice to get a false confession out of me. I would never hurt him like that. And scene. And scene. All those improv and acting classes are really helping. Yeah. What's your name? My name is Taylor. And I'm a victim. What are you a victim of, Taylor? I'm a victim of cruelty. I'm a victim of the cruelty of the predations of my boyfriend. He was the one who got me addicted to drugs. I didn't want to take them, but I didn't want to lose them. It started out innocently enough, and he took me to those parties. It started with the simple marijuana and started with just a little bit here or there until eventually he groomed me. He groomed me into being an addict. And that night he wanted sex from me, and I said no. He thought we were a couple because we had slept once together in high school when I was innocent and I didn't know who he really was. And he said tonight was the night we were going to rekindle our relationship, and I didn't want to. And he tried to force me. I fought back. I fought back against my assailants. I was high on the meth that he gave me. I didn't know what I was doing. I blacked out. I was so scared. Yeah. So give that a shot. Give that a shot. I think the acting classes are paying off, guys. I think they're paying off. Yeah. In fact, when we had sex as high schoolers, it wasn't because I wanted to. He had gotten me drunk. I didn't want to drink, but I thought it was what everyone in Wisconsin did. I didn't want to seem out of place with my friends. But I didn't want to drink, but he made me. And he took advantage of me and he assaulted me. And when he had hurt me, and when he tried to do it again that night, all of it came flooding back to me in an instant. I think I blacked out from the horror of it. I went into a pure fight or flight mode. I just acted out of raw instinct, knowing what he wanted. Then when he was done, then when I was done and saved my life, I wanted him to know, even in death, what it felt like to me. When he did it to me, I felt like I had been torn apart into 1,000 pieces. And I want him to know what it was like, even in death. So I dismembered him so he could feel how I felt. And I penetrated him with the dildo as he penetrated me. Ah! Ah! So, thank you, Adam. Thank you, Adam, for the nice super chat. Amelia says, I'm more convincing than anything she's ever done. Truth. Truth. Well, Nikki, I hope that you will have more money soon. Like the Barbie movie recently came out and told us. I was a victim of the patriarchy. The Barbie movie spoke for me. It is my voice. Tony P, thank you for the 5 gift memberships. It makes it so much better. You can get a membership by hitting that beautiful, beautiful join button. Shona, you can click the beautiful, beautiful button to make sure that you get all the wonderful things. Let's see if Laudner Clips wants to clip that up. Yeah. Laudner Clips, you could perhaps give it the suggestion. The title has uncivil laws acting improv classes paid off, or good times. We love improv, Kurt. Yeah, so the judge is currently like, do I think her lawyer wants her to take a stand? At this point, I don't know. She's in such a deep hole at this point. I don't know. It's like, is there any good that can come from it at this point? Yeah. I mean, the overwhelming advice is that they shouldn't. But she's back in the courtroom, guys. They had their caucus. They had their caucus, and I guess she's made a decision. What has she decided? Will she find out? What do you think, B-Fish? She's pretty screwed either way. Are we going to get closing arguments today? We might. I mean, there's time for it. Yeah, we get closing arguments today. We might get closing arguments today. Hell, if the jury's motivated enough, we might get a verdict today. How long does it take to fill out the forms? Poll results. Okay, 54% of you say no, she will not take the stand, which is probably the safer bet. You would imagine the lawyer's like, this is not a good idea. Although at this point, who knows? At this point, who knows? The jury has to hear from me. The jury has to hear from me. I'm the star. Come on, turn on the audio, long crime.
I've had an extended time period, I appreciate it, to talk to my client. We've talked about this prior to trial, but we talked again about it today. I've advised her that she has an absolute right to testify if she wishes, and she also has a right to not testify if she so chooses. I've given her advice, I've conferred with her, we've talked about this particular issue. It's her decision not to testify and exercise her right to remain silent.
Okay. Then I'll engage her in a colloquy about that in just a minute. But Mr. Freilich, then would it be my understanding that that you have no more witnesses, what you indicated before, and that you'd be, when the jury comes back in, you'll be resting?
That's correct.
Okay. Okay, then, Mr. Business, I need to address you personally. So your attorney told me that he just spoke with you about some of your constitutional rights that are coming up right now, and those rights are that you have an absolute right to testify, and you have an absolute right not to testify. Do you understand that?
Yes.
Okay. Mr. Freilich, the microphone. Not yours,
sorry.
hers.
Sorry about that.
So, Mr. Business, those rights belong to you. They don't belong to Mr. Freilich. They don't belong to the state. They don't belong to me. Those rights belong to you and you alone. Do you understand that?
Yes.
Okay. My understanding from listening to Mr. Freilich is that you've decided that you would like to exercise your right not to testify. Is that correct?
That is.
Okay. Now, I know you've spoken with your attorney. Do you feel you need any more time to talk to your attorney about that decision?
No, I do not.
Has anybody made any threats or promises to you to get you to make that decision here today?
No.
Okay. Any further inquiry you'd like me to make, Mr. Lizet or Mr. Saunders?
No.
Mr. Freilich, any further inquiry you'd like me to make of your client regarding that decision?
Just inquire if there's been any pressure on her.
Okay. Mr. Business, has anybody placed any kind of pressure on you to make that decision?
No.
Okay. All right, well, I'm satisfied, based upon the conversation that I've had here with Ms. Schabusiness, that, number one, she understands her rights. She has both of the rights to testify and to not testify. The issue, of course, being you can't exercise both of those rights at the same time. You can only choose one. She's choosing the right not to testify here today. I'm satisfied that she's done that after consulting with her attorney. They took a little bit of extra time. I gave them better than 10 minutes to speak about that. That was the amount of time that Mr. Freilich wanted, and they were back here when I came into court, so they've had an opportunity to discuss that. Ms. Schabusiness has indicated to me she doesn't need any more time to speak with her attorney about that decision. And I'm satisfied that her decision is freely, voluntarily, and intelligently made here today.
There you go. Knowing, intelligent, and
Of course,
voluntary.
when it comes
There you go.
time to address the jury instructions, Mr. Freilich will have to address, I think it's instruction 315. I think that's the instruction about that I could give to the jury potentially about, and I'm not sure if it's in your packet, but we'll certainly take it up. It's an instruction about instructing the jury that they're not to hold her decision not to testify against her, and that's another choice that she will have to make. If it's not in the packet, I'll get it for you, Mr. Freilich, but I'm sure you've done enough trials, you're aware of that instruction, and I'll make sure it's available to you, and we'll have that
I've never done a
conversation
criminal
later,
trial, and
okay?
I'm aware of the
Yes, Your Honor.
instruction.
Thank you.
Very
So,
good. I'm satisfied, therefore, that Ms. Schabusiness is choosing not to testify.
Well, I've never
And
done a
What we do is, we'll bring the jury
felony
back in.
criminal trial. And I've never done one that's going to
I'll
a
ask
jury.
Mr.
So,
Freilich if he has any other witnesses. Mr. Freilich, based upon the representations he's made, is going to indicate that he's going to rest. And then we have a choice really to make as to how far we want to go today.
Let's
with
do
the
it.
jury sitting here, either try to press forward or to
Finish it
release
today.
the jury and
finish it today.
work on the jury instructions and start tomorrow with instructions and closing arguments. Does the state have a preference as to either of those? Mr. Saunders?
Our preference would be to proceed today.
Any objection to that, Mr. Freilich?
My preference would be to go with the jury instructions today and proceed tomorrow with opening, or with closing statements.
Okay. Well, I can tell you that I don't have to make that decision right at this minute. I'm going to bring the jury in. We're going to finish up the case, and we'll go from there, and then I'll let you know what I've decided as far as that goes. All rise for the jury.
It doesn't look like the state has any rebuttal. They agreed to everything. They agreed to everything the defense wants. There's nothing to rebut, so there's no rebuttal. So yeah, there can't be a rebuttal. There's nothing to rebut. So okay, that's easy.
Okay, be seated. Okay. Ladies and gentlemen, the case is still with the defense, so I'm going to turn to Mr. Freilich. Mr. Freilich, do you have any other witnesses you wish to call?
Your Honor, no other witnesses. Defense rests.
Ladies and gentlemen of the jury, the defense has rested, so the evidentiary portion of this portion of the trial is now concluded. Just to give you a little bit of a roadmap as to what occurs now, the attorneys and I need to work a little bit on finalizing the instructions that I need to give you regarding the law. Then the attorneys would do closing arguments, and then you would go into deliberations. What I'm going to do is I'm going to excuse you again, and I'm going to start working on these jury instructions with the attorneys. I'm not thinking it's going to take us too long, but probably longer than the other breaks you've had. But that's what's going on. Progress is being made. And I'm hoping that within a half hour, maybe slightly more than that, you'll have a better sense of the timing for the rest of today.
If you get these jury's
If I run
instructions
into
done in a
problems,
half hour, I
perhaps
will
would
love you.
dismiss you for today, but
You
at this
you
point, I'm
probably
thinking
should
that
be
I'm
able
gonna
to
have you
do
wait,
that.
and,
That'd be nice
we'll
if you
get
don't
into
want to dick
instructions and
around
closing arguments today.
and just be like, here's
So that's a
here's
bit
what
of
we're
a
doing
roadmap
now.
going forward, but with
Right,
that,
there is a
I'm gonna
reason they're
excuse you
model
again.
instructions.
All rise to the jury.
Right, so most of the instructions should have been written long ago. And like, you know, so if you get this done in a half hour, that'd be great. So let's see. If they take a half hour, they finish this up by 3:15. If they do a half hour each for closing arguments, that's 4:15. The jury gets this
Whether
maybe
to
at
move forward
4:30.
today or break,
Okay, the
send
jury
the
can.
jury
You think
home
the jury
early
can
and
solve
then
this in a half
come back
hour?
tomorrow.
Eh?
I'm always keeping in mind just the timing that we gave them overall, that this trial would take about a week. I'm concerned, I don't know the duration of the next phase of this trial. I'm concerned that if we come back and finish this piece tomorrow, I don't know how long deliberations will go.
I wouldn't worry
on the
about it too
first
much.
phase, and then we have the second phase. So I'm not inclined to stop at this point. I'm inclined to push forward. And having said that, then, I think my judicial assistant should have put on your tables copies of the proposed jury instructions.
All right, let's do
and
jury
verdict forms.
instructions.
Mr. Saunders, did you get a copy of those?
I did.
Mr. Freilich?
Yes.
Okay. Then what I'd like to do is just go through with you those instructions. There are going to need to be some modifications, which my judicial assistant and I will work on when we break. But starting out with, I would propose giving jury instruction 100. I will note that I'm going to jump way to the end after starting at the beginning, that instruction 602 is instruction after evidence has been received on issue of guilt, where a plea of not guilty has been joined with a plea of not guilty by reason of mental disease or defect. It's suggested that this portion, or that this piece, this instruction, be inserted to instruction 100 or given following the instruction on the offense charged. My inclination is to put it right at the end of 100 because in my mind, that's where it makes most sense. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No.
Okay. Then I would intend on giving 103 evidence to find.
I haven't played
Then I
Zelda
would
in a
intend
while.
on giving also
I need to play Zelda some
115,
more.
one defendant, 3 counts.
Zelda kicks ass.
There's a couple of modifications that need to be made here. First of all, on the version that you have, I've used the initials SRT for Mr. Thyrion, and I think we already talked about that way back when we were picking the jury, that we were just going to insert Shad Thyrion, and that's what I would propose to do. In fact, I've already told my judicial assistant to make that change. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
All right. The other thing that I'm not sure if it was corrected on your version, I think it was, and I'll raise this issue. The criminal complaint had the date here as February 22nd, whereas the information had February 23rd. The first draft that I looked at that I had my judicial assistant work on had February 22nd. We changed it to the 23rd. I just want to make sure, I think in your copy that you have, it should say the 23rd. I just want to make sure that that's the
A
date we're
Nintendo
looking
Switch.
at.
Mine
That's the
says February
information.
22nd.
Yeah,
It says the 22nd?
Yes.
Okay, so here's what happened. I made the changes in the version that she gave me. She didn't correct it in the version she gave you. But I'm aware of that issue. It's not something like, my God, I'm not expecting that we're getting all these typos. I knew about that issue. That's why I'm raising it. I fixed it in every other time I've read it to the jury. I had it as the 23rd because that's what the information says. But the first time that these proposed instructions were drafted for me to start reviewing was before we even selected a jury. I was working on these, and it said the 22nd. So I had her change it, but clearly that didn't happen in your version. It should be the 23rd, Mr. Saunders, am I correct?
No. It should be the 22nd.
Okay.
Tuesday the 22nd. The draft we have says Wednesday the 22nd. I think the information's right. The criminal complaint was in error, and that's the state filed an amended criminal complaint fixing that date. In any event, I think based on the testimony, it should be February 22nd.
And so now I'm wondering if I was mistaken, because I recall at the time I was preparing my initial instructions to give to the jury, I asked my judicial assistant to check with the information and make sure that the date that I instructed comported with that. So now I'm thinking she changed your versions, and I'm looking at the old version, because mine says the 23rd, but yours actually has the right date. So I think the 22nd, because that is that's in the information. That's the instruction that I gave to the jury at the beginning. So we'll use the 22nd. Any objection to that, Mr. Freilich? That's what the information
I've never heard of
says.
Aaron
Your
Lambo.
Honor, just
Or a
from
mental
my
monkey.
perspective, I'm looking at a criminal complaint that was filed on March 1st of 2022, and the charging date is Wednesday, February 23rd of 2022. It's confusing. It's complicated because we don't know the exact date when this may or may not have occurred. Was it February 22nd, February 23rd? I don't know.
Sure. There's a couple of things I'd respond to that, Mr. Freilich. First thing I'd respond to that is the information is the charging document, not the criminal complaint. That's the first thing I'd say. The other thing I'd say is Instruction 255, which
Taking a look
has
at
been
this
proposed to
website
me,
now
is the instruction
In
stating
the UK.
state need not
I've never
prove
heard of
exact
this.
date of commission. We'll get to that in a minute, but I'm satisfied that the charging document is the one we need to follow, because that's the official charging document, as opposed to the criminal complaint. So I don't know what was heard at the preliminary hearing in this case, or what the waiver was to, but that's what the charging document says.
Your Honor, just to, the
see
court
your
probably
tag,
already knows
Kestrel.
this, I just want to make a record. The criminal
Have I
complaint does
been
have
disrespecting you,
February
Kestrel? I'm
23rd
sorry.
of 2022 as the charging date, filed on March 1st of 2022, Brown County, Wisconsin. And then the information, which is the charging document, that has a different date, February 22nd of 2022, and that was filed June 2nd of 2022. For me, it's a little bit different because I wasn't the lawyer at that time. It was Attorney Jolly.
Yeah, I'm not always
But I'm
looking
just
at that.
noting
That's
that all
very
for the
true.
record.
And to what end? Are you asking me for something?
I mean, if the state thought it was on the 23rd and then they changed it to the 22nd, it would appear to me that it's not clear what date this allegedly happened.
Okay. Well, what I'm indicating to you is that the charging document is the one that's going to be accurately reflected in the instructions. And I'm also noting 255, which we'll get to in a minute, addresses this very issue. So I'm going to change, I'm not sure if that's an official objection, Mr. Freilich, and I'm not sure what you're suggesting, but the instruction 115 is going to have Tuesday, February 22nd, 2022, in the city of Green Bay, Brown County, Wisconsin. And then where it indicates SRT, it's going to say Shad Thyrion.
Here's what we're doing now.
Then, so 115 contains 110, first-degree intentional homicide. It contains 1193, mutilating a corpse. And in that particular instruction, we need to look at the element piece. And it would seem to me
The only
the word that has
supplement
been
I'm taking
utilized
at the
in this
moment
case
is micronized creatine
dismembered,
monohydrate,
but,
which I've only started taking
we have to
again.
make
I'm on day like 4 or 5 of
alternative
it right
selection.
now.
Mr. Saunders?
Started taking again.
I have no objection to that.
That's the only
Dismembered,
supplement I
dismembered?
I traditionally take
Are
for
you asking
listing.
whether to use mutilated, disfigured, or dismembered?
And I always use Optimum Nutrition
Can I
for my
have a minute to
supplements.
confer with my
I
client?
use their protein powder. I like their brand. I use their monohydrate too. So, in case you want to know what I use at the gym,
Yes, we would
Optimum
agree with
Nutrition.
dismembered.
Okay.
Your Honor, that last comment was an objection, just to let you know.
Then
you do have to drink a lot of
the other,
water with creatine. That's true. Yes.
selection we need to make
Well, I've
there is
got
the
this
very
wonderful
next sentence.
thing,
This
right?
requires that the defendant acted with the purpose to
And try to drink at
conceal
least
a
2 of these a
crime
day.
or avoid
that's,
apprehension, prosecution, or conviction of a crime.
96 ounces, or that's 3 liters.
So
So I try to drink 2 of these a
Mr.
day
Saunders,
plus
does the
whatever I
state have a
drink at the
specific
gym.
request?
I think conceal a crime fits the facts best. So
Mr. Freilich?
Agreed.
Okay. Conceal a crime will be the alternative we'll select in instruction 1193. Then we move on to count 3. That's instruction 1218A, third-degree sexual assault, sexual intercourse without consent. Again, the changes from SRT to Shad Thyrion will be made, although there aren't any other alternative selections that need to be made. So that instruction will be changed. You'll get a chance to review the final version, and then that's the one that I would give. Moving on, I would propose to give instruction 140, burden of proof and presumption of innocence. 145, information, not evidence. 147, improper questions.
And my thing at the gym holds like 28 ounces. I usually go for 2 of those at the gym. It's like another 56 ounces. So
150, stricken testimony. There was very
we're
little
drinking
stricken
plenty of water.
testimony, but I think on only one occasion did I strike any testimony, but I'm going to give 150 because I think it's appropriate. 155, exhibits I will give. 157, remarks of counsel I'll give. There's 158. I've already given that at various times, so I will not give that again. That's recording played to a jury, and it's supposed to be done at the time, and we did that, so I won't give it again. 160, closing arguments of counsel. I will give that one. Next one is 170, circumstantial evidence, and then what I direct the attorney's attention to is the bold or the capitalized instruction indicating that
I'm also not
if
creatine
evidence of
loading.
flight, escape, or concealment has
So
been
even though I
admitted,
just started
see
taking it, I'm just doing
instruction
5 grams a day.
172.
Said it'll
That's
take like
included
3
here.
weeks.
I would propose
For
to
my
give
body to
both
adjust to that.
Instruction 170
But I don't want to do
and
creatine loading.
172.
So
Any objection to that, Mr.
we'll just do it
Saunders?
slow.
no.
Mr. Freilich?
Oh, Your Honor.
It'll take a little
Okay.
time.
On 172, we need to make some selections. The first line, evidence has been presented relating to the defendant's conduct after the
Gotta
alleged
get
crime was
buff.
committed or after the defendant was accused of the crime. I think the first option is the appropriate one. Mr. Saunders?
I agree.
Mr. Freilich?
I agree.
All right, option 1 will be selected. Okay, moving on, 180. There needs to be some work on that.
I gotta
I
do
intend
some
to give
chest press
180.
today.
The capitalized portion of the instruction
curls.
indicates, add the following if a statement resulting from an
Some lat pull
unrecorded
down.
custodial interrogation is admitted at trial for a felony and no exception applies. I don't think that applies in this case because although there was custodial interrogation that was offered, it wasn't unrecorded. In fact, it was entirely recorded. So I think I take that paragraph out, but then continue on with the bottom paragraph. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
Taking off that bottom paragraph where it says continue with the following in all cases, you want
No.
to excise that?
No. The portion that says continue with the following in all cases, I would give it because, well, this is a part of all cases. The paragraph I would excise is the one just before it, where it starts, it is the policy of this state to make an audio or audio and visual recording. I'd take that paragraph out.
In the brackets?
Yes.
Okay, I have no objection to that.
Okay. Then I'll move on. I'll give 190, weight of evidence.
No classes tonight. No, my classes are
195,
Monday and
jurors'
Tuesday nights.
knowledge.
So tonight is
I would
gym,
give,
and I'm excited
200
about that
expert
because I haven't been to the
testimony
gym
general.
in like
So there's some selections
4
that need
days
to be
now.
made there, or at least addressed. It says continue
I was
with the
supposed to
following
go
if
on
experts have
Monday.
given conflicting testimony.
and I couldn't
I
go
don't
because of
think that's the
this.
case, so I would
I couldn't
propose
go
to
yesterday because of
delete
this.
that portion. Any objection, Mr. Saunders?
So I'm
No.
kind of looking
Mr.
forward to
Freilich?
getting to the gym
And the
today so I
bottom
can
bracket
get
as
back
well,
into
the two
it.
brackets?
Right, that's the part that they're saying.
These all-day
Continue with
streams
the
plus
following.
classes
Just
are
asking if
not
you're gonna
good
take
for
those
my
out.
workouts
Okay, yes.
because I don't have time.
Okay, 255, this is the one, state need not prove exact date of commission, specific date alleged. That essentially says if you find that the offense charge was committed by the defendant, it is not necessary for the state to prove that the offense was committed on the precise date alleged in the information. If the evidence shows beyond a reasonable doubt that the offense was committed on a date near the date alleged, that is
You know,
sufficient.
especially like these, man. The
You're
court
asking for
starts
that,
at
Mr. Saunders?
court starts at
Yes.
8:30.
Mr. Freilich, any objection?
The court doesn't stop till 5.
Well,
They only give me an hour for lunch. It's not enough time really to go get a workout in.
They filed the
To
information,
do a short
which is the
workout
charging
maybe, but it'd
document
be
with a
so
different
tight
date.
between that and the shower.
But
It's like,
then they're saying they don't have
you
to
know?
prove the exact date, so I'm kind of confused.
then I have class at
That, Your Honor,
7.
So I've lodged an objection to that.
Okay,
And
I'm
like
gonna
the last
give
2 days, I've just been taking an
55
hour
and
nap because I've
satisfied
been crashing.
that the date
You
of
know,
the
I gotta leave
information
my
is the
house
date
at
that
like
needs to be instructed because that's the charging document. I'm also
6:30 or
satisfied that
6:15
this
to
is
get that
appropriate,
down there in time.
Instruction
Then it ends
to give
at
in light of, frankly,
9:30.
the entirety of the evidence that I've
I'm not
heard,
sure when I'm supposed to get a workout in.
satisfied that,
If I didn't believe in sleep, I guess I could do it
frankly, given
before
that
it's the court
the
started at
timing,
8:30.
the time of day that's
That'd be
occurring,
that. It's like so if I can, but then
knowing
again,
that
of course,
one
I'm just
day
tired
flip
all
to
the time.
next,
I'm
may
tired all
not
the time.
be so easy to pin
So if
down.
I choose to not
I'm
believe in
satisfied
sleep
this is an
anymore,
appropriate
then
instruction. I'm going to give that as revised.
I have to be ready by 8, which
I'm
means
then
if I'm
going
going to do an hour at
give
the gym, it means I
300
have to leave my house
credibility
at
of
about
witnesses.
6:30.
There is an option at the end that says,
Super.
give the following paragraph only when the defendant testifies. Given that the defendant didn't testify, I would propose to delete that and the bracketed paragraph just below it. And, but then continue on with the last paragraph indicating there is no magic way for you to evaluate the testimony. Any objection to that, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
Hit is out of the question.
Moving on.
Because I don't have
325,
the,
impeachment of witness,
I
prior
don't have the
conviction, or
cardio for
juvenile
hit.
adjudication. I don't think anyone was
I don't have
asked
the
that
cardio.
question.
I don't have the
I don't think
cardio.
anybody was impeached with a
Anything
prior conviction.
explosive,
So I propose to take
dynamic,
325 out. Mr. Saunders, any objection?
intense.
No.
Mr. Freilich?
I agree.
Okay, that'll be out.
That's right out.
327, impeachment of defendant as witness, prior conviction or a juvenile adjudication. The defendant didn't testify. I propose to take that out. Any objection, Mr. Saunders?
No.
Mr. Freilich?
No, Your Honor.
That'll be out. 460, closing instruction, I would propose to give that. Then I would propose 484, verdict submitted for one defendant, 3 counts, separate verdict on each count required. I would propose to give 515, unanimous verdict and selection of presiding juror. And that's it. So, you'll have another opportunity to look at these after I've made those revisions, but such as they are, Mr. Saunders, any objection to the entirety of those instructions or anything I'm missing or that you'd like me to add?
Yeah, 2 additions that I'd propose. Madam Clerk, the copies. Okay, I have one for the courts and council. The first is based on some testimony.
We'll
that
figure
we
something
heard.
out.
It'd be our request to make clear that voluntary intoxication is not a defense. In the case, there's not a pattern jury instruction that really says that. There's a part of 755A that does have that sentence, and the state would ask that just that sentence be read, given the state of the law and the state of the voluntary intoxication defense.
So you're saying this is coming out of 755A?
Correct. It's not
Have I
directly
tried
applicable, but as
methylated
modified, I
vitamin
believe
B
it's accurate.
supplements? No, but I'll look into it. Methylated vitamin B complex. Nature Made complex? Okay. Yeah, Nature Made? Okay. B6, B12, methylfolate. Methyl B12.
Mr. Freilich,
Yes.
any response to their request for 755A? Just so you know, Mr. Freilich, and I know you don't have the benefit of having your computer sitting right in front of you regarding 755A. 755A.
Oh, I can get now methyl B12 5000 mcg. I might do that.
Involuntary intoxication or drug condition. So it looks as if Mr. Saunders has utilized that pattern instruction. Mr. Saunders, if I'm correct, you've utilized that pattern instruction to craft this, and he's proposing that this be given. Any objection to that?
No, Your Honor.
Okay.
I know the law.
Okay. So that's fine. I will give this modified 755A Generally, other than sometimes
Dream
rearranging where
poolside?
the closing
I don't know about that.
instruction goes, I give these in numerical order. That would put it right at the end. I don't propose to put it right at the end because the last one I generally give is 515, unanimous verdict and selection of a presiding juror. I think that is the best to have at the end. Proposal as to where we insert it, Mr. Saunders?
I would say right after the 115, the substantive jury instructions. That makes sense.
Any objection to inserting it there, Mr. Freilich, right after 115, the substantive instructions?
Your Honor, if I could just have a minute.
Burbine and methyl. So methyl B12 is what I'm looking for. Methyl B12
Yes, that makes sense.
and burbine, berbrine.
Okay, we've taken that one up, then, before I move on, do you have a Word document with these on it? That
I
you
do.
can forward to my judicial assistant?
Okay.
One of you, so that, because I'm going to be heading over there shortly to finish these off, and we'll need it. But let's look at, you don't have to do that till we're done, but let's look at your other request then, Mr. Saunders.
Yeah, so obviously
All
that
B
issue,
complex to get a B complex.
this issue has been addressed in
Turmeric?
litigation. There was a motion to dismiss.
Guys, I don't want to just start
regarding,
taking
the state
8
doesn't need
different
to prove
supplements.
that a crime victim was alive
Berberine?
or deceased at the time of sexual
Berberine.
intercourse. And I think the state just envisioned a jury having that question, given the two elements don't clearly explain what I think is an accurate statement of the law. So our request would be to add something to address that issue, because obviously it's the facts and circumstances that the state's alleging in this case.
Okay. Well, let me just, before I turn to Mr.
I'll go to
Freeland,
GNC or
to
something and
take a
get
look
some.
at his position on
I'll go to
this.
GNC and get some methyl B complex.
I'm just going to pull up the statute. Because we did have this issue that was raised as, at the motion hearing on June 13th. This was heard by the court. And I know at that point, I denied a motion to dismiss that count. And the assertion in that motion was that had been filed by the defense, that really the charge should be dismissed because at the time the alleged victim was deceased. And then we looked at the statute.
Turmeric is used by hikers instead of aspirin. I usually just take a Advil every time I go to the gym. I pregame an Advil every time I go to the gym. I have a bottle of Advil in my car, and as I'm walking into the gym, I just take an Advil. Seems to help. Pre-gaming Advil is the way to go.
Okay, and I know it, so the instruction, the one that I'm proposing to give in any event that everybody's agreed to, 1218A, references the statute, 940.225
I only take one,
sub
though,
3
so.
sub A. And so I've looked at that statute, and under 940.225, sub 7, it indicates specifically, this section applies whether a victim is dead or alive at the time of the sexual contact or sexual intercourse. Okay, so what you're proposing that be done in this case, because of issues that have been raised and frankly that were argued on that date, that it be inserted, that the following language be inserted, quote, "It is immaterial whether Shad Thyrion is dead or alive at the time of the sexual intercourse," close quote. That's what you're asking to be added?
Yes.
Mr. Freilich, any objection
Super
to that
B
language?
energy complex.
Your Honor, I know
Nature
that
made.
the
Ooh.
jury instruction says person. What about the statute? What we have here, and not to be crass, but human remains, body parts that are in different locations. So that was the issue that I had with that.
I'm sorry, your question, you said that the statute says person?
I know the jury instruction says person, but I don't know if the statute says that, but it talks about any part of a person's body. So it talks about a person, and what we have here is, a body part, body parts.
Statute says, 3A, says as follows. Whoever has sexual intercourse with a person without the consent of that person is guilty of a class, is guilty of a felony. So the instruction mirrors the statute as far as person. So when you get down to sub 7, where it says this section applies whether a victim is dead or alive at the time of the sexual contact or sexual intercourse, they're using the word person, or using the word victim instead of person in sub 7, presumably, because at that point in time, using the word person could get confusing as to whether you're talking about a victim or a perpetrator. If you just said, this section applies whether a person is dead or alive, and you perpetrate, I don't want to get into all the machinations, but it would seem as if the word victim is used in sub 7, perhaps for that reason.
It's fine. Don't worry
So
about
the
it.
question, of course, is whether there's an objection to insertion of the language, it is immaterial whether Shad Thyrion is dead or alive at the time of the sexual intercourse. Any objection to that?
I know that's in the statute, but is that in the pattern jury instruction that we have, Your Honor?
It is not.
It's not.
He's
So
asking for it to be added in.
Yeah, he wants to add something, correct?
Yes.
I'm going to object to that.
Too bad.
I'm satisfied that, first of all, adding that language in is a correct statement of the law. It is. It's not as if modifying the instruction to something that incorrectly outlines what the law is. It's an accurate statement of the law. Secondly, this is a bit of an unusual circumstance where typically when you see these assaults occur, you have someone in court testifying that they were the victim of a sexual assault. That's different, of course, when you have someone who is deceased. So the circumstances of this case are a little bit unique. It's already been put into this case. It was argued, and I'm satisfied that it's an appropriate addition in this particular case.
Feel free to tell the Court of
These
Appeals
pattern
about how
jury
the judge
instructions
screwed up
are not
by
any
adding a
means
sentence from the
mandated
statute
by law to be
into the
used.
jury
They're-
instructions.
They're guides.
I'm sure the
and
Court of
while we
Appeals will
usually follow
love hearing
them,
about it.
It's certainly permissible for courts to look at them and modify them as needed, and I think this is an appropriate addition. So I'm going to grant that request. And so that will be added to instruction 115, the subpart under 1218A. Anything else, Mr. Saunders?
No, thank you.
Right, Mr. Freilich, again, you're going to get a final opportunity to review these, but any additions or changes that you're looking for besides what we've already discussed?
No, Your Honor, thank you very much.
Okay. Let me just ask you then
Not
about
bad.
the proposed verdict forms. Obviously, there are 3 counts. There will be 6 verdict forms, 1 for guilty and 1 for not guilty for each count. Mr. Saunders, have you had an opportunity to review those?
Yes.
Right. Changes or corrections on those?
No.
Mr. Freilich?
One moment, please. Your Honor, I have reviewed all the verdict forms. They appear to be in proper order.
Okay. My judicial assistant and I are going to get underway on these right away. Mr. Saunders, if you can make sure you send a Word version over to her. I invite the attorneys to get up and move around if you want, but don't get far, because as soon as I'm done, I want to get back on the record, and I don't know how long it's going to take me. So just stay close, but you can certainly move about the courthouse, okay?
Okay, thank you.
We're in recess.
All right, guys. Yeah, so the workout stuff is going well. I'm happy to say I'm enjoying it. I'm enjoying the lifting. And I want to lift more. I want to increase my muscle mass. and see what I can do and do more reps at higher weights. So creatine is one of the most I'm familiar with the literature on creatine monohydrate. It's one of the most well-researched supplements, at least it seems to me, to help you basically achieve more reps, to reduce muscle fatigue so that you can do more reps. So I'm exactly like that, yeah. And it seems like it's safe as long as you take it at like 5 grams a day. It seems like it's safe basically indefinitely. If you take it at high doses for long enough, you can shoot your kidneys. But as long as you like actually take only 5 grams a day, which is all you need, you're fine. And so that's really the only supplement I need, I think, plus the Advil, if we're counting Advil as a supplement, which we can. So I'm excited about that. And then I have my casein protein powder when I make smoothies, in case I want a smoothie, like instead of ice cream. So one days when I'm good, I'll put together a smoothie with some casein protein and stuff like that. But I also look into this methylanized, or whatever we're saying it, whatever, B vitamin. See if I can get a methylanized B complex, preferably that one that has a relatively high amount of B12 in it. I think would be good. So what flavor? Oh, for the protein powder, just traditional chocolate. I usually throw in some peanut butter powder. I used to get the stuff that was chocolate peanut butter, but it's like, why? I just get the powdered peanut butter and just throw a couple scoops in there, and it's a little bit better. So just traditional chocolate protein powder. Nothing fancy. Sinead O'Connor passed. Okay, cool. I don't have a particular opinion of it, but fine. And we went to the gym 13 times last month, and we're going to go to the gym today. And I'm looking forward to crushing things as I do my best Arnold Schwarzenegger impression. We're going to do upper body today. My legs are still a little sore, and lower back's a little sore, so we're going to do upper body work today. So I think we're going to do some chest press today. We're going to do some curl today. We'll do some lat pull down. Maybe we'll do some overhead press. Maybe we'll do some row today. That sounds good. We'll also probably do back extension machine. Help make my lower back a little bit stronger. We could do some fly. We could do some chest fly today. That'd be good. I do like chest fly. We could definitely do some chest fly today. That'd be good. Yeah. So we'll roll around today. It'll be an interesting workout today. I'll have to like sub out everything my app tells me to do, but that's okay. My one of the people in Rackets chat last night was trying to get under my skin and was saying, "Oh, I've seen you post on your community tab your workouts. Can you post what tacos you eat for your physique?" And I just responded to the guy just simply saying, as long as we're making steps in the right direction, we're making progress about ourselves, you should be fine. This is how I feel about it, right? It's like, yeah, I know I'm fat and overweight. Why do you think I'm fat and overweight. Where should I go? The gym. That sounds like a good place to go. That sounds like a good place to go for the fat and overweight guy. How about going to the gym? So I will, be hopefully less fat and overweight, or at least stronger. One of the two. So, yeah. I mean, yeah, I get winded just doing like the most simple body stuff. Like putting on my shoes is hard sometimes, or like putting on shoes and socks is hard sometimes, just because like I have to like bend down and stuff, and it's hard because like how out of shape I am. But it's like, well, you know what we could do to fix that problem? What if we went to the gym and lifted weights? Because I can do that, and it's fun. So let's do that. The workout tracking app I'm using at the moment is an app called Volt, Volt. I also recommend Fitbod between the two. Both are very good. So pick one of those. Volt is probably better if you want more traditional lifts. And Fitbod is probably better if you want a more generalized workout experience. But both are very good. $20-minute walk a day. Yeah, the last time I went to do elliptical, I was having problems doing elliptical, but that's okay. We're making progress. Progress is good. Anything in the right direction is good. And then, although it hasn't been a problem as much lately, when I first started doing workouts, everyone's like, "Oh, do this workout, do this workout, do this workout." I'm like, guys, just support me in what I'm doing. I have a plan. It's a plan. Let's stick to the plan. Is it a perfect plan? Probably not. It's a plan. Let's do the plan. So fortunately, I think people have gotten the memo and are stopping with like, oh, you should do this workout or this workout or this workout's the right one. Or you should be doing this thing or this thing. I'm like, guys, I'm going to the gym. I'm working out. It's a progress. It's progress. Let's just validate that. How about validation that we're in the right place? Yeah. And I'm happy with it. I'm happy with the progress I'm making. It's working for me. So like, wonder if I can like, wait, can I, so we'll do chest press okay. So we'll do chest press today. We'll do cable row today, standing cable row. We'll do some lat raise today. We'll do lat pull down today. And instead of Arnold press, we'll do shoulder press. So we'll do chest press, cable row, lat raise, lat pull down, and shoulder press today. I don't think we'll do cardio today, though. We might do fly instead. I'm not tracking my weight right now in terms of how much I weigh. I'm not tracking my weight right now. That is not information I'm interested in right now. Yeah, they're getting ready. They're hunting around. The gym can be a bit crowded sometimes. It's a nice gym, though. Come as you are, as you were, as I want you to be, as a friend, as a trend, as a known enemy. Yeah. People can be cruel, yeah. Or at least one guy can be cruel. Most of the people are very supportive of me. Most people support me in what I'm doing. The afternoon for the gym, I'm not particularly good in showing up in the mornings. I've had more success in the afternoons when when I used to work in an office, I used to go like when I was done with work. I used to go for like 5. So yeah, going in the early evening, afternoon is much more consistent with what I've done in the past. You have a friend that talks about shit about people who don't belong at the gym? Yeah, if you're really out of weight and you're really out of shape, the gym is probably the best place for you to be. What else? Yeah, you're the wrong person. You're out of shape. Why are you at a gym? Now, what kind of comment is that, right? Look at how out of shape you are. Why are you at a gym? Yeah. I feel like you answered your own question on that one, Mindset is sniping me again? Okay, well, that's cool. We were just talking about my workouts and my workout plans for today. So for the mindset people that might be sniping us today, we're just going over my workout plan for today. So we are planning on doing seated chest press, standing cable row. We're going to do lat raise, seated machine lat raise. We'll do some lat pull down, and then we're going to do some seated overhead press, and possibly also some chest fly with the chest fly machine, and also possibly adding in a back extension machine to work on my lower back issues, because I have lower back issues and I need to gain some strength there. So possibly doing some reps on lower back as well. And we were talking about different supplements that I'm taking or looking at taking. So right now I'm doing just creatine monohydrate to help with the lifting, to help volume and help increase volume, and so that I can get my gains. And I have this unrealistic goal of 4-plating a bench press, which for those of you who are not familiar with gym speak would mean 405 pounds of bench press, which is a lot, but maybe we'll see. I have a long way to go between there and there. We'll see. I have a long way to go. My best bench press when I was doing it before was about I want to say it was about 270 or something like that. So going to 405 is a lot, but hey, we'll see what we can do. Yeah. Yeah. And the improv classes, of course, have been going really well. So I've been doing improv on Mondays and Tuesday nights, which also incidentally has made it hard to go to the gym with the all-day streaming. Has been a bit of a problem. So I don't know how that's going to work with trials in the future, because you do all-day stream and you're doing a class in the evening. And the class itself, by the way, is 2.5 hours. Plus you have to get to and from class. So that's a lot of day. That's a lot of time. That eats up all your time. So the only thing that I could possibly do is be like, go to the gym first thing in the morning and then just add to my day even more. So if I abhor sleep, I could make it work. So I'm not sure how we're going to make that work. But right now I'm doing Monday improv and Tuesday improv. Monday is more game based. So more like whose line is it anyway is Monday. And then Tuesdays is narrative, where we're improving a play. So we've been practicing how to improv a 30-minute play. Right. So we obviously have to create characters. We have to create characters, create story arc, create narrative, create flow, work to create some sort of conflict for the protagonist to overcome, overcome the conflict, resolution, and we're doing pretty good. I have to say, we're doing pretty good with the making up a play on the fly. We're doing pretty good. Yesterday, when we made up the play on the fly, yesterday's play we made up on the fly was we start in a bar, and I start as the bartender, and I just start as the bartender, and the other guy comes in and he's talking about how he's dropping out of medical school, right? And then so we're just getting started, and so then we move to the next scene, and now he's talking to his friend about how he dropped out of medical school. And it's like, okay, so he's going to be the protagonist. So that's the story. This guy and his journey dropping out of medical school, or his conflict with medical school, is now going to be the story. So it's like, okay, so he's the protagonist, right? All right, so he comes in, he's having trouble paying rent. He meets with his medical advisor, who turns out to be this really snooty woman. This dog is like really, really snooty. She wears like Chanel suits, to the hospital. Just really rich, arrogant, snooty woman. Then we meet his parents, and I play one of the parents in the role, who are these really arrogant, uptight, really rich people who are just like, they buy and they use money to control, right? So it's like, oh, do you like that apartment that you're in? Well, if you want to continue living there, you're going to go to medical school, and so forth and so on. And then, of course, our protagonist, starts at off Broadway. He has to pay to be an actor at this school, but somehow he manages to hit it out of the park, and he wins an award. He wins a Tony, and his parents are there cheering him on as he's saying how happy he is as an artist, and that's the play. So we wrote that in real time on the fly with nothing. And I was like, that worked out pretty well. I thought it worked out fine. I thought it was good. Could you stream it? No. It doesn't really play well on camera. I don't think. It doesn't really play well on camera. It would seem very. I think it would come off too cringy on camera. I thought it went well, but if you watched it back, you'd be like, "Who are these complete rank amateurs? What bullshit acting is this?" Right? It would be too. It would be cringy to watch. It doesn't play well on tape. It doesn't play well on tape. And the same thing with the game improv. Like whose line is it anyway? Those are pros. Those are the pros, right? We're doing something that vaguely resembles whose line is it anyway, but it is not as good. We think it's good, but we also understand it's not Ryan Stiles good or Wayne Brady good. We are not in that class of category. So there's a lot of distance between us and them. So we got to start from somewhere, but it wouldn't play well on tape. Yeah, play it by ear, fun musical improv. I've seen that. It's a good thing. Yeah, I've seen that. Those guys are really good. We cannot play at that level. We are working on it. We are not that good. So we are having a lot of fun and just having a good time doing all that. Court's still courting over here. So that's what I'm doing. And then also I'm looking to take a class, which I think is on Thursdays, from this acting school that's called Meisner School of Acting, which has a reputation. It has a reputation of being a very intensive and very emotionally vulnerable form of acting. It has a reputation of being kind of culty and has a reputation of being very exposing and breaking people down emotionally and psychologically. So it has a reputation of a very intensive school of acting. So I've been looking of taking that on Thursdays to try to add to my craft. So we'll see. It also has a reputation for involving a lot of repetition. So you do like the same thing just over and 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 over again. So it has a reputation. So we'll see. So we'll see if that's all good and how that works. I was just looking to see if Vices was sniping me, and at least he's not at the moment. He was sniping Ricada, but he hasn't been sniping me recently. So this entire conversation, which was originally intended for Vices or Mindset's benefit, has not happened. Mindset is currently sniping Vices. I could snipe them. Would you want to do snipe Inception? That can be fun. Let's do a little snipe Inception. Hold on.
Steve Gosney, if you're reading the legal mindset chat, scratch your nose. Come on, let's get a little nose scratch, guys. Guys,
Nose scratch option?
Nose scratch.
Yeah.
Just do it real quick. Just do it real quick for the chat.
Okay.
Yeah, he did it. He did it. He did it, guys. He did it. He did the nose scratch.
I mean, gosh,
he did it.
This trial
Scratch
is
it,
moving
scratch it,
along.
guys.
We're getting
Scratch
to
it,
where
guys.
we need to get into phase 2.
He did it. He did it. He did it. He
The
did it.
judge
We
is
got
coming
guys.
back with the instructions.
We got guys. He
Very,
gave
very
the
soon.
baseball inside
So-
baseball signal.
Are we
yeah,
getting-
yeah.
The
He's
court's
in it.
coming
He's
back.
In it. He's in it.
So are they going to
How
stream the
long
He
court?
knows.
So are they
He's
streaming the
reading
court?
four
Or are we
chats.
doing
A
the
verdict
court?
of sorts?
He's reading 4 chats right now. I love
How long
it.
does it take to introduce yourself and then say what do we think?
I'll note that on the next page, I've inserted 602. I indicated that that's where I thought it was most appropriate to insert 602. So I'll give 100 followed by 602. Then I'll give 103, evidence defined. 115, one defendant, 3 counts. Changes that have been outlined in there, we've talked about. It'll say the counts will be listed as Tuesday, February 22nd, and I've revised the initials used for Mr. Thyrion. It will say Shad Thyrion. I've made the agreed upon elections on the 1193, mutilating a corpse, and then of course we move into 1218A, and I have inserted the language that was requested by the state. Mr. Freilich, I believe, objected to that.
Do you not have sound from the court?
I was going to give it, and that sentence is, of course, under the
You should.
subheading meaning of did not consent.
Do you not have
It's the very
sound?
last sentence, and I added that in. Then I'll give the modified 755A that was agreed upon and designed by Mr. Saunders. I will give 140 burden of proof and presumption of innocence. 145, information, not evidence. 147, improper questions. 148, objections of counsel, evidence received over objection. 150, stricken testimony. 155, exhibits. 157, remarks of counsel. 160, closing arguments of counsel. I'll give 170, circumstantial evidence. I'll give 172, circumstantial evidence, flight, escape, concealment. I will give 180, statements of defendant. 190, weight of evidence. 195, juror's knowledge. 200, expert testimony, general. I'll give 255, state need not prove exact date of commission. I'll give 300, credibility of witnesses. I'll give 460, closing instruction. 484, verdict submitted for 1 defendant, 3 counts, separate verdict on each count. I'll give 515, unanimous verdict and selection of presiding juror. We'll then select the alternates. A couple of things I want to take up. First of all, I did want to, because we didn't bring this up at our instruction conference, but it's not too big of a problem. I asked my clerk if she could hand one of those to each of the attorneys. This is what Mr. Freilich and I had spoken about earlier, 315. And Mr. Freilich, I know you didn't have a copy of that, but you can have a brief moment to review that with your client and take a few minutes to talk with her about whether or not you and she would like me to give that.
Okay, Your Honor. Thank you.
To give that.
Okay,
How you
Hold
doing,
on,
legal
I gotta go back
mindset?
and
You having a
pause
good
for
day?
The Chunkata.
Still doing the drunk? You still doing the
Well,
stream sniping?
Big Kurt Energy plays.
Hope you're having a good one,
To
sir.
give that.
Okay,
How you
Hold
doing,
on,
legal
I gotta go back
mindset?
and
You having a good
pause.
day?
The Chunkata.
Still doing the drunk? You still doing the stream sniping?
Big Kurt Energy plays. Oh, we're in trouble now.
Hope you're having a good one, sir.
No.
okay,
How you doing?
13, I'm fine with that. And I showed it to my client.
Okay, and I appreciate that, Mr. Freilich. I think I need more than just I'm fine with that. This has got to be something that you either ask me to give or ask me not to give. And I'm going to have a colloquy with your client about it. Do you need some time to speak with her about it? Because if you do, I can leave the bench and come back in a few minutes.
Yeah, maybe that would be a good idea, Your Honor.
All right. We'll take about 5 minutes and have a conversation with her, Mr. Freilich.
Thank you.
That was way too much fun. That was way too much fun. I need to see this back. I need to watch this back. This is just too funny. Hold on. I gotta see this. All right, let's check this out in all of this glory so we can see how this played out. This is too much fun.
Leave her in the
Saunders.
sun. All right.
I will give one third.
I got a constant prescription.
Let's go
I have
here.
to do
Let's
it
go
now.
to Kurt. Let's see how Kurt is doing here. Is he still alive?
To give that.
Okay,
Oh, I've got to hold on. I got to go back and pause
you.
the Chunkata. Well, Big Kurt Energy plays.
To give that.
okay,
How you
Hold
doing,
on,
legal
I gotta go back
mindset?
and
You having a good
pause
day?
The Chunkata.
Still doing the drunk? You still doing the stream sniping?
Big Kurt Energy plays.
Oh, we're in trouble now. Hope you're having a good one, sir.
No.
okay.
How you doing,
Hold on,
legal
I gotta go
mindset?
back
You having a
and
good day?
pause the Chunkata.
I can't do it. I can't do this. I can't do this. Oh no. Hold on. Are we gonna go over to Joe? Let's gotta go over to. Good times. Good times. That was fun. Yeah, that's what that's
Decorum,
Opening arguments
you
not
know,
that
fun. Oh Lord, good times. Should we could pop over in Legal Mindset. We could join. I wonder if he sent out a link for his stream. Let me see if he sent out a link. I don't know if he did. See if I could pop over his stream, that'd be fun. No, he didn't send out a stream. I sent him a link, but he didn't send me a link. He probably thought I didn't want one because I was streaming myself. That's fine. Blah. So yeah, the court is just finishing up the jury instructions, and we'll go from there. Busted him. All right. So what else you guys want to talk about? So yeah, I'm planning to move to Houston in probably January, February. And because Nate the lawyer there, of course, lives there now, and attorney Tom already lives there, so there'll be 3 of us living in Houston. It's not quite Content House, but we make do with what we have. I haven't been able to convince them to do Content House. Apparently, they have like families, and they want to have their own space for their own thing. La-di-da-di-da. So okay. So I'm looking to move out there in January, February, so that we would be there at the same time. And I'd like to finish up as much of the acting stuff as I can before I move out there, because I don't know what's going to be available in Houston. I'm sure there will be things, but I'd like to finish out what I'm doing. So I'm trying to finish out the improv classes at the school I'm at, and trying to take these classes from Meisner to try to work on all that stuff. So I'd continue to rent. I like renting, to be honest. I like having the flexibility. I don't know that I want to necessarily remain in Houston. I might only be there for a year or 2 and then move on to something else. I could very easily see myself winding up in either San Antonio or Fort Worth. So I don't think Houston is forever. So I could definitely see myself going there for a year or 2 and then moving either to Fort Worth or San Antonio. So we'll see. Unless, of course, I meet a honey who wants to stay in Houston. That'd be good.
Yes. So I just want to put this on the record. I talked to my client. We've talked a number of times throughout the duration of my representation. I've advised her that if the case went to a jury trial, she has a right to testify. She has a right to take the witness stand. She has a right to testify in her own defense. But anything that is said could possibly be used against her. So she understands that she has a constitutional right to testify. I also told her that she has an absolute constitutional right not to testify. She has a right to remain silent. She can invoke her Fifth Amendment privileges against self-incrimination. And we've talked about this at length on numerous occasions, several times today. We've reviewed this jury instruction 315, and she's indicated to me that she wishes to exercise her right to remain silent. Before, when you asked the question, I wasn't quite sure what you were asking, but I agree to the court reading instruction 315 to the jury. Thank you.
So you're asking that I read this instruction to the jury?
Yes.
Okay. Ms. Schabusiness, you have a right to have this instruction read, or you have a right not to have the instruction read. And that right belongs to you and to you alone. Do you understand that?
Yes, I do.
Okay. Your attorney indicates to me that he would like me to have this instruction read to the jury. Is that correct?
Yes.
And you agree with that?
Yes.
You feel you need any more time to talk to him about that decision?
No.
Okay. I'm satisfied.
That was a
First of all,
really long
Mr.
prelude
Saunders, any further,
for would you
inquiry
like the
you'd to
instruction
make
read?
regarding
Well, Your Honor, I
No.
talked to my
Mr. Fraley?
client
No,
about
Your Honor,
their
thank
right
you.
to
I'm
remain silent, their right to
satisfied
testify.
that, Mr.
I also
Business
talked to them
indicated,
about the role of
she
a
would like
jury
me to
trial
read
in our
315
system
to the
and
jury.
what a judge does in a jury trial,
result
such
of
as
that,
yourself. I told
I'm
my
going to
client
do
that
that.
a judge rules
The
on the
only other,
admissibility of
topic I wanna
evidence
take
and
up
rules
with the
on
attorneys, and then, of course, I'll ask
objections
generally
and
whether you
stains
have
and
anything you wanna
decides
raise
rules
with
of
me.
evidence. I also informed them
Oftentimes I get a
about the role of
request.
a
I usually read these in
prosecutor
order.
and
Oftentimes I get a request
inform them.
to
I
have
also told them about the role of
160
our
closing
media
arguments
in our great country
read
and
just
how
before
our
you give
media
the
might be
closing
covering
arguments,
this case and
which would
commenting
be
on
right
it. And
after 3:15.
also talked to her about how
Before
I became a lawyer. You know, I
closings,
first
and then
started my
obviously after
career
closings, I
in
read
high
460.
school where I decided
Any
I wanted
objection
to
to my
become a
reading,
lawyer. And,
160
you
just
know, Mr.
before,
Business, when she was in high
closings?
school,
Mr.
was
Saunders?
contemplating, you know, carving
Mr.
people
Fraley?
up,
No, Your
which
Honor.
wasn't really my direction. I didn't want to be able to become a
160
doctor.
then. I'll slide that in just before 3:15. Strike that, just after 3:15. Okay. Mr. Saunders, are there any other topics or issues regarding the instructions that you'd like to bring up with me?
No.
You're satisfied with the instructions and the order in which I propose to give them?
Yes.
Mr. Freilich, any topics you'd like to raise regarding the instructions
No, I would not, Your Honor. I'm in agreement with the form of the instructions.
and the order with which I propose to give them?
Yes, I am.
Very good. Then, before I ask you about durations of closings, I guess what I would just indicate is I intend to bring the jury out. I intend to instruct them right up through the closing instruction. Attorneys can close. There will be potentially some rebuttal closing. And then we'll select the alternate, and the deliberations will be underway.
We may wrap this thing up tonight, boys.
Before we do that, Mr. Saunders,
No.
Mr. Freilich.
No, Your Honor.
Okay. Then with that, we'll bring the jury in.
Ladies and gentlemen of the jury, I'm proud to be American, and my client, Mr. Business, is proud to be an American. In our great country of ours, we have one demand, that the state prove their case beyond a reasonable doubt. Ladies and gentlemen of the jury, they have not done that. There are so many holes in their case. Ooh. And you must put the state to their burden of proof. It's better that 10 guilty men go free than one innocent should suffer. Do the right thing. Set my client free. Also, can I interest you in a 2006 Chrysler Town & Country? It's got air conditioning and captain's chairs. It's also got great cargo room.
Okay, be seated. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. In this first phase of the trial, you have heard evidence that dealt solely with the defendant's conduct during the alleged incident. You are to determine only whether the defendant is guilty of the charges of first-degree intentional homicide, mutilating a corpse, and third-degree sexual assault. If you find the defendant not guilty, the trial will be over. If you find the defendant guilty, the trial will proceed to the second phase, where you will determine whether the defendant was not responsible by reason of mental disease or defect. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third,
You have
any
5
facts
jokes
to which the
about her?
lawyers have agreed or
5
stipulated, or
things?
which the court has directed you to find. Anything you may have seen or
5
heard
jokes
outside
about
the
Keller
courtroom
Schabusiness.
is not evidence. You are to
bones
decide the
connected
case
to the leg
solely on
bone.
the evidence offered and
1.
received at trial.
I put both heads in a
The
bucket.
first count of the
2.
information in this case charges that
My
Count
minivan
1,
has
the
plenty of
above-named
high
defendant
room.
on or about
3.
Tuesday, February 22nd, 2022, in the city of Green Bay, Brown County, Wisconsin, did cause the death of Shad Thyrion with the intent to kill that person, contrary to sections 940.01 sub 1 sub A, 939.62 sub 1 sub C Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. First, the defendant caused the death of Shad
can't hear
Thyrion.
it?
Cause
can't hear
means
this?
that the defendant's
Maybe when I talk on top of it?
act was
Deal.
a substantial factor in producing the death.
Deal.
Second, that the defendant acted
Every
with
word
the
I say
intent
is more
to kill
important than what the
Shad
court
Thyrion.
says. Welcome to
Intent to
Uncivil
kill
Law.
means that the defendant had the mental purpose to take the life of another human being or was aware that her conduct was practically certain to cause the death of another human being.
Every word I say is
While
of
the
the
law
utmost
requires that the
importance.
defendant acted with the
And
intent
must
to
be-
kill, it does not
you,
require
the
that
members
the
of the chat,
intent
must pay
exists
attention to my every
for
word,
any
despite what the
particular
court
length of
codes.
time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts,
Hello, Ashley
words, and
shows up.
statements, if any, and from the
One
facts
of my
and
improv
circumstances in this
instructors is named
case
Ashley.
bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to establish guilt, you should give it the weight you believe it deserves under all the circumstances. Beyond a reasonable doubt that the defendant caused the death of Shad Thyrion with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. The second count of the information charges that Count 2, the above-named defendant on or about Tuesday, February 22nd, 2022, in the city of Green Bay, Brown County, Wisconsin, did 1 sub C of the Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Section 940.11 sub 1 of the Criminal Code of Wisconsin is violated by one who mutilates, disfigures, or dismembers a corpse with the intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. First, that the defendant dismembered a corpse. Second, that the defendant dismembered a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find out intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The third count of the information charges that, count 3, the above-named defendant on or about Tuesday, February 22nd, 2022, in the city of Green Bay, Brown County, Wisconsin, did have sexual intercourse with Shad Thyrion without that person's consent, contrary to sections 940.225 sub 3 sub A and 939.62 sub 1 sub B of the Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense be charged beyond a reasonable doubt. Third-degree sexual assault, as defined in section 940.225 sub 3 sub A of the Criminal Code of Wisconsin, is committed by one who has sexual intercourse with another person without consent. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. First, that the defendant had sexual intercourse with Shad Thyrion. Second, that Shad Thyrion did not consent to the sexual intercourse. Sexual intercourse means any intrusion, however slight, of any part of a person's body or of any object into the genitalia or anal opening of another. Emission of semen is not required. Did not consent means that Shad Thyrion did not freely agree to have sexual intercourse with the defendant. In deciding whether Shad Thyrion did not consent, you should consider what the defendant said and did, along with all the other facts and circumstances. This element does not require that Shad Thyrion offered physical resistance. It is immaterial whether Shad Thyrion is dead or alive at the time of the sexual intercourse. If you are satisfied beyond a reasonable doubt that both elements of third-degree sexual assault have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. An intoxicated or drugged condition is a defense to criminal liability only if it is involuntarily produced.
I guess I have a purple background typically too, so it's not fair comment. It's like
in reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty, unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty.
I cannot reconcile it with any reasonable hypothesis.
The term reasonable doubt means a doubt based upon reason and common sense.
I'm not even sure I have
It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life.
She is so incredibly guilty.
A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt.
She wasn't there.
A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. An information is nothing more than a written formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection was made. By allowing the testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Remarks of the attorneys are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether decide. By the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things. Whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was actually restated here at trial. Whether the statement or any part of it ought to be believed.
Anyone have any
You
recommendations?
should consider the facts and circumstances surrounding the making of each statement, along with all of the other evidence in determining how much weight, if any, the statement deserves. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than the testimony of another witness, or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. If you find that the offense charge was committed by the defendant, it is not necessary for the state to prove that the offense was committed on the precise date alleged in the information. If the evidence shows beyond a reasonable doubt that the offense was committed on a date near the alleged date, that is sufficient. It is the duty of the jury to scrutinize and to weigh the testimony of each witness and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based upon the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or discredit the testimony. Then, give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence and under the instructions given to you by the court. We're now ready for the attorneys to give their closing arguments. I want to speak briefly, however, to both the attorneys that are giving the closing arguments, if you could approach.
Exciting. Exciting. Ladies and gentlemen of the jury, as long as I keep talking, you can't vote to convict. So I'd like to tell you some things. First of all, this has been alleged to have occurred in Green Bay, Wisconsin. I'd like to start telling you about the history of Wisconsin and Green Bay. It's a long and illustrious story.
Because I know they're lengthy. Having said that, Mr. Saunders, are you prepared to give a closing argument?
Yes, Your Honor.
Very good. Go ahead.
Good afternoon.
She is at.
I
Here's
want to
closing
start
argument.
with something
She
that
is
we
so
heard
incredibly
yesterday, actually,
guilty,
Monday,
ladies and gentlemen.
in opening statements.
She is so totally guilty.
Counsel told us that there's always two sides to every story,
Yeah.
and with all due respect, this is not one of those stories. This is a story that pretty clearly shows what happened. It's a story of the defendant taking a dog collar that was around her friend's neck and pulling it so hard and for so long and with such force that it caused his death. That in that moment she made a deliberate choice to end her friend's life. She then, after the fact, degrades his body, engages in sexual acts with him. This is a story of the defendant then dismembering him and leaving his remains all over the house for his mother to find. And this isn't the state's story. This isn't law enforcement's story. It's the defendant's story, as you heard today, right? So as we go through this, it's easy to sit here and say, yes, the defendant confessed, and it's true. She confessed to every single element that you will see that the state needs to prove. But we didn't just stop there, right? We could have been done with this case on Monday, played her interview and called it a day. But you should expect more, right? We have the burden of proof, and obviously we called a number of witnesses to establish what this story shows. So I want to walk through that story. And I know there's a lot of law that was just read to you, but I'm a visual learner, so I like to see kind of what we're looking at here. So as I go through these three offenses, there's really, as you'll see, 6 things the state needs to prove beyond a reasonable doubt. Not every fact that was testified to, not what time somebody got to Scott Holmes' house at the end of the night. The 6 elements are what the state needs to prove to you beyond a reasonable doubt. Okay? So first, count 1, first-degree intentional homicide. First, that the defendant caused the death of Shad, and that she, second, acted with intent to kill him. Okay? And again, as I already mentioned, as we go through these elements, you heard earlier this morning that the defendant is acknowledging every element that we hear. Okay? Independent of the information you heard today, with the investigation you heard, the DNA, the other information, Dr. Tranquita's testimony, I would argue would prove all these elements as well. But you have on top of that the defendant's admissions to all these elements. Okay? So the defendant caused the death of Shad. I mean, that should be fairly clear here. Obviously, she admits that. You heard Dr. Tranquita's testimony of how Shad died, the cause and the manner of death, strangulation, excessive force being placed on the neck, producing his death. That was the sole cause of death that we heard. So let's talk about intent, right? Because that admittedly sometimes is a tricky topic, right? We can never know anyone's intent truly, and as you're told, you're not going into the mind of somebody, right? Kind of looking at all the facts and circumstances that you see. In this case, you have the benefit of the defendant opening up her mind to you and telling you what her intent was here. But you also have other signs, right? So what does intent mean? that somebody had the mental purpose to do something, right, some volition, or that they're aware that what they're doing is practically certain to cause that result, right? And you heard both, really, from the defendant. So I want to walk through that because there's a lot of points in that interview where the defendant is telling you exactly what her intent was in this case, right? His face was turning purple, right? She describes that and how he's coughing up blood. And you know that's accurate, right? Because you heard Dr. Tranquita's testimony and you saw those photographs.
We did.
She's seeing that in person, and yet what does she say? I still didn't stop. No. She felt a heartbeat at one point, right? She talks about feeling his heartbeat, and she kept pulling more, and he wouldn't die. And I just wanted him, and I was like, damn. Right? She admits even that Shad's struggling in this moment, that he's fighting back, right? You heard from Dr. Tranquita as well about how it looked like at one point there were signs of that, where the collar slipped up along the tongue. She's telling you, I was waiting for him to die. I liked it. She figured I'm already this far, and she's pantomiming the act. It's like she's starting a lawnmower. That's how hard she's pulling on this chain, right?
Yeah.
Took 3 to 5 minutes, she thinks. And again, that's consistent with Dr. Tranquita, right? This is not an accident. This isn't a whoops. This is an intentional act.
This is a lot of
right?
whoops.
You
This
don't
is a
need to
very
prove that she
that'd be a
went
good
to that
defense.
house with this
This
intent.
is just
We
a
talked about that
5-minute
going
long
here. We
whoops.
kind of talked through
Which
that
of us have
concept
not been
of
there,
how
ladies and gentlemen of the
these
jury?
instructed intent
5
to
minutes
be,
of whoopsing.
formed the instant
Which
before an act. The instant
those of you
before
who have not
pull the
sinned past
trigger,
the first
the
stone.
instant in this case, before Mr. Business decides, I'm going to go further and pull on this chain so hard that it causes the result that we saw in Shad, right? So we have the mental purpose, right, from the defendant's own mouth, and that's consistent with everything else we're seeing in the case. But you also have Detective Kemp asking her, you know, I mean, in that moment, did you kind of realize if you kept pulling on that chain that he would die? She's like, probably, yeah. Yeah, she was aware of that. Right, so that goes to this kind of the second either-or part of intent, right? Was aware that her conduct was practically certain to cause that result, and it's probably obvious as you sit here of what's going to happen when you're pulling a metal chain like that hard for that long, seeing the result of what's happening to another person, that is going to be the result, right?
Yep.
So you're told you can't look into a person's mind.
I can look a little into her mind, and it's a scary place, my friends.
But as I mentioned, you also have other indicators, right? You have Dr. Tranquita's testimony describing the amount of force that would need to have been done to cause the injuries that he's observing, right? Down to the inner neck muscles, and he was talking about how strong and thick those neck muscles are, and there was hemorrhaging that deep. That's how hard and how long and how much injury the defendant was causing. Right? This isn't an accident. If it's an accident, you're not going forward. You're not seeing this result and keep pulling. You're calling for help. You're stopping. You're certainly not after the fact, after you finally finish, then cutting up his body, right? You have all the evidence in this case points to intent, right? You have her acts after the fact, like I said. You know, if this was an accident, something happens, right? You call for help, and you have the exact opposite. You have the defendant cutting him up and cleaning up, getting rid of the remains, pouring it down the shower. We heard a lot of testimony about that. Kind of wiping up with the Clorox wipes, which the defendant is acknowledging as well. So you have the defendant's statement in the case, and it lines up with everything else in the case, right? Even little facts that she's remembering and telling you about, right? The timeline of the February 21st night, right? We heard from A.J. Gannon. You heard the stipulated testimony from Mr. Tomes. You heard from Mike Thyrion. It's all consistent. Yeah, they were coming and going. You then heard from Steve Hendricks about, yep, they got back sometime in the early morning, and I let them in. Defendant's telling you that same thing. Steve is talking about how at one point during the day on the 22nd, she comes up and asks for her eyeglasses, and we heard the defendant talk about that as well. We heard Detective Graff testify about that. So everything she's saying is consistent with what we're objectively seeing, what law enforcement is finding. And in some respects, the defendant's leading the investigation, right? Because when they get there, when law enforcement gets there, we saw Officer Wanish's body cam. We heard from Detective Scanlon and even Dr. Tranquita about how it was really hard to determine what exactly happened when they first got there. And all that information is being provided by the defendant. Okay? So it's an intentional act. She had the mental purpose. We heard about that. It's not, as I talked about, it can be formed at any time before the act, right? It doesn't need to be premeditated. That's not the law in this state. And it's really important, too, to not confuse this with motive, right? We heard evidence about motive, right, and her interest in Jeffrey Dahmer and all that entails. But intent doesn't mean motive. This is what intent means, and we proved intent, right? She caused his death, and she acted intentionally, and she told you as much. So those are the two elements. Those are the two things the state needs to prove beyond a reasonable doubt. Count 2, mutilating a corpse. So again, there's two elements for this crime. First, the defendant dismembered a corpse. Second, did so with the intent to conceal a crime. So the first element, I think, is pretty clear, right? And we heard extensive testimony from many people, and we saw Dr. Tranquita's diagrams, and obviously I can't imagine this element is going to be in dispute, right? And so again, though, we have this concept of intent, the purpose to conceal a crime, right? And I mean, as you're instructed, you use your common sense. Like, why is somebody going to this length, not only cutting up a body? We heard from Dr. Tranquita about the multiple sort of start and stop kind of signs, the total evisceration of Shad, bagging him into other bags and attempting to carry out. Like, that's the intent, right? We use our common sense that that's why you're doing that. But again, she was asked about this, the defendant. And remember in that February 28th interview, the second interview with Detective Groff and Detective Scanlon, she's saying exactly what her intent was, right? It was because there's other people in the house. Like, what am I going to do? Leave the body and have Mom find it? She admits, again, this was her intent, and it's obvious with our common sense, but it shows that the state has proved both elements of this crime as well. Okay, count 3. It's third-degree sexual assault. So the defendant had sexual intercourse with Shad and did so without consent. So let's talk about the first part. Sexual intercourse is defined in this state as inserting any object into the genital or anal opening of another, or engaging in oral contact with the penis. We heard about both, right? The defendant admitted to both. She's talking about how she's put the dildo in Chad's anus after she killed him. She's talking about how she was sucking on his penis, and there were other phrases used to that effect. So again, we have, for both elements here, the defendant's admissions. And we heard from Mr. Scott, didn't we? We heard from Mr. Scott about the DNA testing that was done, right? And for some of the reasons why, even though the defendant's DNA is on that dildo in Shad's house, Shad's DNA wasn't found on there, and nothing excludes that possibility. And again, everything the defendant's telling you is consistent with other things you're seeing. So there's no reason to believe, a reasonable hypothesis to believe, that she's not also telling you what's happened in this case too, right, for this count. And the second element, did not consent. I mean, that, as you're instructed, is kind of inferred by the fact that at the time that the defendant's telling you she's engaging in these acts, that Shad's deceased, right? So he's not in a position to consent. Okay. So those are the two elements for count 3. So in total, 6 elements for the 3 offenses. And again, you're given a lot of law on how to assess credibility of witnesses, and that's good, and you should follow it. Really, you kind of just use your common sense as jurors. And again, the defendant's telling you what happened, and there's nothing in the case to disbelieve what she's saying, right? So you have the defendant's admissions, as I mentioned earlier. There's other evidence that kind of just only should bolster the conviction in the defendant's guilt, right? We heard from Kevin Scott, who heard or testified about the DNA testing he did. Shad's blood on the defendant's hands, on her clothing, on the sweatpants, about how the knives that were found had Shad's blood on them, right? Even absent her confession, I mean, there's ample evidence here to convict on all 3 counts. You have many witnesses coming in to talk about the integrity of the investigation, how law enforcement didn't just take the confession and go home, right? We do more, right? Send things in for DNA. We speak with other witnesses. We corroborate the defendant's timeline of things. You heard all that. And that's really important, right? We have the burden of proof. And we talked about that, and we embrace that burden of proof. You should hold us to that standard as the state to prove something beyond a reasonable doubt. And that's why we call people from Madison to come up to talk for 5 minutes about, I received this piece of evidence, and it was fine. And I returned that piece of evidence, and it was fine. Right? Because it's important. We want to show that law enforcement did a thorough investigation in this case. And they did. Because we have the burden of proof. You're instructed on what the burden of proof is and what it's not, right? It's a reasonable doubt, a reasonable hypothesis consistent with consistent with innocence. You should find the defendant not guilty. But you're not searching for doubt. You're ultimately searching for the truth. So even if it's a heavy burden, it doesn't mean the decision is difficult in cases. You are instructed not to search for doubt. You're to search for the truth. And there's not a reasonable hypothesis in this case consistent with the defendant's innocence. There just isn't, right? There's one truth in this case. There's one side of the story, and it happens to be the defendant's story as well, but it's consistent with everyone else's story. It's because that story is the truth of what the defendant did to her friend Shad. And based on that, we would ask that you return guilty verdicts on all 3 counts. Thank you.
You know, when you got it, right? You don't have to overcomplicate it. Is it a good closing? Not in particular. You know, he's nervous. It's disconnected. It's not particularly good in narrative arc. You know, it's lackluster. But you know, when you got it,
Ladies and gentlemen of the jury,
you don't need a lot.
Mr. Saunders.
So as
Well,
a closing
as
argument
the
goes, it's
attorney
like
for
a
the
5.
Taylor Denise Schabusiness,
But you know,
I'd like to
it doesn't really matter
share
very
with
much.
you that I believe this case is a puzzling, unclear, confusing, and bizarre set of facts.
I agree.
It is unknown what really happened between February 22nd of 2022 and February 23rd of 2022. What we do know in this case,
It wasn't
is
as
that
bad as his opening,
numerous
though.
law enforcement
His opening was definitely worse.
officers
So he got a little
testified.
bit
We had
better.
Detectives, we had police officers, we had Dr. Trunkita, and DNA experts, forensic specialists, lots of different people, some citizen witnesses. I'd ask that you consider setting aside your emotions and decide this case based on the facts that are presented, that have been presented. You've sat here for the last 3 days. You've been here in court. I know that you've listened very closely. But don't assume anything. When you deliberate about all of the facts. What we do know is that law enforcement officers on February 23rd of 2022 went to 829 Stony Brook Lane in Green Bay, this small Cape Cod home, and made contact with the occupants, Tara Pakinich, Stephen Hendricks, and Ava Wheelock was woken up, but they were all sitting at the kitchen table, and officers came in
I'd like to
see what was
speak
going
in
on.
a sort
There
of
was
a
concern,
dull
obviously, that
monotone.
There was a bucket down at the end of the stairs.
All passion has been driven out of my life.
Detective Groff, that this was an ongoing investigation, law enforcement, they were trying to piece this together. It was an unusual situation, and so they were trying to find out what happened. Unfortunately, I believe it was Officer Plonky and Officer Wanish, they testified, they came here and indicated that they went down to check out what was in the basement, and there was it was the head of Shad Thyrion in that black Fleet Farm bucket. And the investigation continued on. But what I submit to you, ladies and gentlemen, is that there really are no eyewitnesses as to what really happened down in the basement.
You are correct. There are no eyewitnesses.
There's
You've
no
got
Taylor
Mr.
Schabusiness there, no other people there. And so
You are
that'll be something
you are
to
correct.
consider and think
You are correct. There is no one in the basement.
Then
Good
law
job.
enforcement realized that there was a secondary scene, and that was at 2353 Eastman Avenue, apartment 1 of that parking lot. And you saw the video. The officers, I think it was Officer Garth Russell, and a couple of other ones, they walked up. Microphone. Sorry. Thank you. The officers walked up and they parked a distance away, and they walked up in the snow, and they saw a line of cars in front of the apartment complex.
There were many cars parked at the
And they
apartment
saw
complex.
that, they saw a
The
minivan.
blood
It was
in
a
the snow
gold
could have been from any of the
Town and
cars.
Country Chrysler minivan, and that was a vehicle of concern.
I mean,
Had some
lots
snow
of
on the
people were
back
walking
windshield.
into and out of that
There were vehicles
apartment
on either
complex.
side.
That blood in the snow
And,
could have come from anywhere.
The officers walked up, and they they saw some lights on the van, and then they saw someone come out the front door, and it was my client. It was Taylor Schabusiness. At that point, she was arrested by Officer Russell, and another officer then realized there was a male inside of the apartment number 1 down the hall. Ended up being Scott Tomes. And he was told to lay on the ground and held at gunpoint, and then he was arrested. So 2 people were taken from the apartment building and taken down to the police station. There was a search of the Eastman Avenue apartment. We don't have any body parts there. I would submit that there really wasn't anything of evidentiary value there. And
Once again, you are essentially correct.
That
there
was-
nothing
that was
of
that.
particular evidentiary value in this
later
apartment.
on,
Good
officers
work.
and detectives realized that minivan was something that they were concerned about, so that was taken down to the police storage garage. And then we found out that from Dr. Tranquita and some of the other forensic specialists, Andre, I believe it was investigator Andre, and Zarnecki. And so they donned Tyvek gear, protective PPE equipment, and they methodically investigated the back of the minivan, and they found the crock pot box that was in a laundry basket sitting on a seat, and there were human remains in there. Nobody saw Taylor Schabusiness driving this minivan. So these are some of the facts that
She
you
said that
gotta
she was going to take.
think about. Don't rush to judgment, but talk about it, analyze it. As jurors, you have to analyze the facts that you hear, and you have to apply the law that the judge gives you. It's a daunting task.
Is it ethical for a prosecutor to get up there during a rebuttal and
So
just be
then
like,
we hear-
my only rebuttal is
You
she
saw the-
completely and
the,
totally did it. Find her guilty.
The video.
Thank you.
The
Can you
interview
do that?
between Detective Groff and my client, Taylor Schabusiness. She was
I
taken
honestly
down
don't
to
know
the
the
Green
answer
Bay
to my
Police
own question.
Department.
Is that too much?
Photographs were taken of her, and clothes were taken, and she was put in a yellow suit and then later a blue suit, but she was asked questions.
But she
And
wasn't put in a red
gotta
suit.
remember
Only
what
blue
she said,
and yellow.
what questions were
Because
being
not
asked.
red, And red, you know,
she
is the
did
color
say-
of murder.
During the interview, I can't think right now. I'm effing nuts. She said that she was up all night, that the body would rebuild itself. She said weird, odd things. Consider her credibility. Consider what she says. Consider what she said to Detective Groff or Detective Scanlon. She said stuff, I would submit that she said things that didn't make sense. She says, I have no idea to some of the questions that the detectives asked her. You remember seeing the video on the screen. I'd ask that you recall that she had inappropriate laughs, inappropriate smiling, odd responses.
As she has during this entire trial.
I would submit that she
Counselor.
indicated that she did not have sex. She did not have penis to vagina intercourse with Shad Thyrion. She indicated that she came to the residence and they went downstairs and within 5 minutes they got to it, whatever that means.
Well, murder.
She talked about during the interview with Detective Groff rebuilding muscle or rebuilding into muscle. Sometimes she wasn't responsive. She talked about hearing gunshots. But I believe Detective Groff said that there were no
English
gunshots
business
in the area of
is
Stony
trying to
Brook,
figure out what her lawyer is
Eastman
talking about
Avenue, or
right
some
now.
other place. She said she was paranoid.
What do you think it's
She
like
said
inside
weird
her
things
head?
like,
right
I don't
now?
like open spaces.
What do you think
I
is
don't
inside
like
her
open
head
spaces.
right now?
No clothes came off, no kissing. She said that she allegedly put the dildo into Mr. Thyrion's backside, his butt area, his anal area.
Mm-hmm.
There's no DNA. We heard from Kevin Scott, DNA expert. He must have done real well in school, in chemistry and all that. But the swab from the dildo, item J1, it says the possible contribution of DNA from Shad Thyrion is inconclusive due to the complexity of the mixture. I would argue that his DNA is not on the dildo. So there's,
Okay.
I would argue that even though the state is charging out third-degree sexual assault, there is no shred of evidence to support that particular charge.
Except her own
And
confession.
I'd ask that you take that into account.
Except her saying it happened.
No evidence at the Eastman Avenue apartment.
Except literally the words out of her own mouth.
When Detective Groff had my client come down to the Green Bay Police Department with Detective Kevin Kempf, they were talking with her for a while. The interview was maybe 3 hours or so.
She looks 20
Then they
years
took
older
a
than
break
she.
because Ms. Schabusiness had
She looks like she's
Cuts.
early 40s.
on her thumb, scratches on her palms, other cuts on her fingers. Some of them were deep. You saw the pictures because I believe they were published. And she was taken over to St. Vincent's Hospital for medical evaluation. I would submit that the blood on her hands may have been her own because of the
Maybe Miss
the deep,
Business needs a
cuts
workout
that
plan
she
so
had
that she
suffered,
can bring back
or
her
that she had.
former body. She needs a workout plan. Maybe she can join me in doing some lifts.
The defense had subpoenaed Mr. Scott Holmes. He was unavailable, and he gave an account of that night. And he had indicated, at least on Monday night, that would have been February 21st, that Taylor Schabusiness and her friend Shad came over. He had seen Shad before, but didn't know his name. And then he thought that they hooked up to do meth. And then he talked about his vehicle. And he talked about that Taylor Schabusiness had used his vehicle in the past and didn't get permission on that particular night. Then he indicated that he was drinking. And then he indicated that Taylor Schabusiness returned to his house around midnight with his vehicle, went to her bedroom, and he had a suspicion that she may have been high on drugs. And then he had indicated that Taylor had the bedroom and that he would sleep in his chair. So that's, something else that you have to think about. We heard from Lieutenant Buckman. He was
There is
a
no
veteran
piece
on
of
the
paper
Green Bay
that you
Police
have there
Department.
that's going to save you.
And that he was doing some investigating, and he wasn't sure if Taylor Schabusiness
I wonder if he's
was
going
a
to go up to the
suspect
prosecutor
or a
and be like,
victim,
hey, you guys want to get a
because
drink or
it was,
something?
an ongoing new investigation. So
I'm
that's
buying.
something you have to take into account as well.
You guys want to get a cocktail?
The state brought up some photographs, a picture of Taylor with her phone. And young girls, I submit, they like their phones. So do all kids, young people. They like their phones, and they look up things on the internet for a variety of different reasons: shock value, curiosity. But we have a situation here where Taylor did do some searches about Jeffrey Dahmer. I would submit that that's a ruse, that doesn't necessarily mean anything, and that people search the internet for all kinds of things on the internet, and that it's for shock value. So that shouldn't really play any part in this case. I would ask that you discount that and set that aside.
Uh-huh.
Now, I would argue that I would argue that it's not a clear case here.
I don't know. It's pretty clear, Counselor.
Was this an accidental death?
No.
Did Taylor Schabusiness kill Shad Thyrion?
Yes,
Was there intent to kill Shad Thyrion?
definitely.
Did Taylor Schabusiness have the mental purpose to kill Shad Thyrion?
Yes.
Different theories, different things for you to think about.
I'm
You
good.
are all like analysts, and you have to assess and decipher the facts. The facts here are very complicated,
No, they're really
Confusing.
not that complicated, to be honest.
unclear.
They're not actually
Two different
exceptionally
locations.
complicated as
No
far as facts
eyewitnesses.
go. They're actually not that complicated.
Taylor Schabusiness.
It's
we
brutal,
learned
but it's actually
she
not
went to
complicated.
school with
It's
Shad
actually pretty
Thyrion,
simple.
Middle school, Bayport High School. They were friends. They hung out. You heard from A.J. Gannon. He hung out with them as well. Can you trust what someone says when they're hopped up on meth, on drugs? The state wants you to look into Taylor Schabusiness's mind to find out what her intent was. And that's a difficult task.
I'm good. Thanks.
Did she have a clear mind on February 22nd of 2022
Doesn't matter.
as to what was really going on?
Clear enough, my friend.
Accidents can happen.
Really?
When accidents happen, people can make other choices in a panic. Something for you to think about.
Those choices including cutting up a corpse
This
and putting the body
sexual
in
assault
various
charge,
places.
how can you have sexual intercourse with the facts that have been laid out and presented to you? It's mind-boggling.
Sub 7, we've discussed it a little bit already.
How can you have sex when genitals are in one place and bodies in a different place?
Once again, sub 7.
It's
Thanks.
foggy. It's cloudy.
No, no.
It's hard to imagine. Almost impossible to try and figure out what did or didn't happen.
I'm
I would
good.
submit to you that no sexual assault occurred. I'd ask that you find her not guilty of third-degree sexual assault.
Uh-huh.
You can't rely on everything Taylor Schabusiness says.
I can when
Think
it's
about that,
completely
please.
consistent with every other piece of evidence.
She
in
chose
the
not to
case.
testify under our Constitution of the United States of America. She doesn't have to testify. It's what the law provides. You don't
You are
have to
correct,
take
sir.
the witness stand. have
You
a
are correct.
right to remain silent, and you can't use that fact alone against her.
I promise you that is
I would
really
argue
not that
that
much of the consideration.
Based on all of the evidence and the testimony in this case, that you find my client not guilty of all the charges. Thank you very much for your time.
Once again, can I get up there and just be like, she is so absolutely, totally guilty, it's beyond all understanding. Your business is Shaw
This
business.
is puzzling.
Guilty.
This case is bizarre. This case is in absolutely no way unclear. It is crystal clear what happened to Shad Thyrion, and we know that. We know that because the defendant told you. She told you what she did to Shad Thyrion. Is it bizarre? Is it unnatural? Is it strange? Yes, absolutely. People do bizarre, unnatural, strange things. They engage in criminal conduct. People kill other people and they dismember them. That's what Taylor Schabusiness did. And we know exactly what she did because the words from her mouth told you with specificity what she did. Can we trust always what Taylor Schabusiness says? No, but as Mr. Saunders told you, we trust but we verify. We didn't stop at taking her statement. We corroborated. She guided the investigation with the specificity of her statement. How can we not trust her statement when she describes in detail the mechanism of injury, which is exactly what is described and confirmed by Dr. Tranquita? Excessive strangulation
Sandra,
over
for
a
the
period of
gift
time
memberships.
with layers of injury, exactly as she described it. Described that his tongue would be out. She described that. Dr. Tranquita described that and showed you that. She described his struggle. He's struggling for his life and she continues to pull that chain, demonstrating her intent to kill Shad Thyrion. And we know that because we see that in the physical evidence. We see the marks on Shad's tongue. We see the damage to his neck. She described to you what she did with his body after she killed Shad. And we know that it's true because the body parts were exactly where she told you they were. Detectives are finding everything she says on scene, and you saw it with your own eyes, that just what she told you is exactly where those things were located in that residence. She wasn't cloudy. She wasn't unclear. She wasn't hopped up on drugs. She knew where to find the drugs. She knew where they'd find the pipe. She knew where they'd find the chains. She knew where they'd find the knives. She knew the name of the bag where the body parts were going to be located. She could tell you that she put the organs in plastic bags. She could tell you that she cleaned up with Clorox wipes and she put them in the bags as well. She could tell you that his lower extremities were in the car. This is the most specific confession anyone could ask for, and it is corroborated in detail by the work of the Green Bay Police Department. This is bizarre, this is strange, this is unnatural, but it is in no way unclear. We know exactly what happened. We know exactly what Taylor intended to happen for all three of these offenses. She engaged in intentional conduct in each of these acts. You are asked to look at each of the 6 elements, and there are only the 6 elements that Attorney Saunders described to you. That as to count 1, she did cause Shad's death. There is no doubt she had the mental purpose to do that. And that she knew that her conduct was practically certain to cause it. She described to you how she visualized him struggling, blood coming out of his mouth, but she did not stop. He's turning purple, but she did not stop. He's coughing up blood. He's pissing himself, in her words, but she did not stop. This was a deliberate choice on her part to kill Shad Thyrion, and she knew that her actions were going to cause that. And in fact, she was asked whether or not she liked it, and she confirmed that she liked it. She was asked whether she was sexually aroused by killing him, and she said she was. Her mental purpose was clear. As to the mutilating the corpse, again, there's no doubt that she intentionally did that. She described the detail. She described her frustration as she's mutilating this corpse, and she described her purpose in doing so. How else am I going to get the body out of the house? How else am I going to get away with this if I don't cut this body up? And she didn't just cut it up and leave it there. She cut it up, she packaged it, she cleaned up after herself. Her purpose in dismembering Shad was clear. She wanted to attempt to get away with this crime. A crime that she intentionally committed, a crime that was not accidental, that was not a surprise to her, that she didn't wake up from this nightmare and then call the police and call Shad's mom. No, she made the second deliberate choice. After deliberately choosing to kill him, she deliberately chooses to dismember him and attempt to cover up her crimes. For counsel to say that we can't merely accept the word of the defendant, you're asked routinely in sexual assault cases, juries are asked routinely to take the word of a crime victim with no physical evidence. We don't have to take the word of the crime victim. We have the word of the defendant who confesses to this crime and tells you exactly what she did, again with specificity, and tells you, you know what, I did this and I did it with that dildo. And here's where you can find the dildo. It's in the wall, it's in the box, I put it away. And what happened? They found it in the box, put away exactly where she described that it would be. And she clearly
good rebuttal.
was sexually aroused by this whole incident, and she described that to you herself. So clearly it follows, it makes sense, it's logical, it is reasonable that she did exactly what she told you she did. There is absolutely no reasonable hypothesis consistent with her innocence. The only hypothesis, the only choice that you have before you here today is to find Taylor Schabusiness guilty of each and every count for which she is charged. All of those elements have been proven beyond a reasonable doubt, and I ask that you return a verdict of guilty. Thank you.
Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duties steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 6 forms of verdict will be submitted to you concerning the charges against the defendant, Taylor Schabusiness. 1 reading, we the jury find the defendant, Taylor Schabusiness, guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, guilty of mutilating a corpse as charged in count 2 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, not guilty of mutilating a corpse as charged in count 2 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, guilty of third-degree sexual assault as charged in count 3 of the information. Another reading, we the jury find the defendant, Taylor Schabusiness, not guilty of third-degree sexual assault as charged in count 3 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have a question, the court will talk with the attorneys before answering it, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court, and the court may ask each of you if you agree with this verdict. Now, ladies and gentlemen, this is the unfortunate time, because now is the time when we select the alternate jurors. Let me tell you what the process is going to be. The computer has selected 4 of you. We're going to read those names here shortly. If your name is read, I'm going to ask that you simply stand up and go have a seat in that first pew right there, because I'm going to want to address you, the first pew right here, because it's open. And I'm going to address you after the other jurors have been excused. The remaining 12 jurors are going to participate in the deliberation process, and you will accompany the bailiffs to the jury room. If you're selected as an alternate, your participation in the case at this point will be concluded. I will make sure, however, that you are addressed by a bailiff who will assist you in retrieving any items that you may have in the jury room. So at this time, then, I'm going to ask that the clerk read the names of the 4 jurors that have been selected by the
You're reading their names?
Nicholas Rozek,
I know a Nicholas Rosen.
Sean,
I don't know if he lives in Wisconsin, but I know a Nicholas Rosen. Oh. Well, I'm guessing that's Nicholas Rosen. Yep, there's a guy. Well, we're showing some jurors' faces now. I really hope their service is concluded. Way to go for exposing their face. Genius. Good work. Good work, Long Crime. Good work.
that you will, to the utmost of your ability, keep all jurors sworn on this trial in some private and convenient place, subject to the direction
That isn't the
of
Nicholas
court
Rosen I
until
know,
they
by the
agree
way.
on their verdict
So,
or are discharged
that
by
solves
the
that-
court,
that solves that
and you
mystery.
will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God.
I do.
Thank you.
All rise for the jury.
Dude, you would think that the court TV people would be like, experienced at this point, since they do it all the time. But they suck at it. They get it wrong every time. How bad can they be?
Right, be seated. I want to first address Mr. Rozek, Mr. Lynette, Mr. Beerhalls, and Ms. Schrader. I want to thank you very much for your service on this case. You've all paid careful attention. I've been able to observe all of you throughout the trial, and I really appreciate that, and so do all the parties. At this time, your service in this case is completed. Many jurors ask if they're allowed to discuss the case with others at the conclusion of their service. Because your role in this case is over, you are not prohibited from discussing the case with anyone. However, you should know that you do not have to discuss the case with anyone or answer any questions about it from anyone other than from the court. This includes the parties, the lawyers, the media, or anyone else. If you do decide to discuss this case with anyone, I would suggest that you treat any discussion with a degree of solemnity such that whatever you do say, you would be willing to say in the presence of your fellow jurors or under oath here in open court in the presence of the parties. Finally, should any of you have any questions before you leave today, please let the bailiff know before you leave. And you can confer with me at any time before answering any questions asked by anyone if you choose. The bailiff is standing right back there. I'm just going to ask you to get up then and accompany her out that door, and if there's anything that you need to retrieve. But again, thank you for your service.
Okay.
Anything to take up before we recess? Mr. Saunders?
No.
Mr. Freilich?
Not at this time.
Very good. Then we are in recess. I'd ask the parties to remain very close here to the courtroom for at least 30 minutes. Oftentimes, if questions come in, they come in early. After that, if you just simply leave a cell phone number where we can reach you, then you're free to.
We'll revert it in
but still
30
ask you to
minutes.
Remain close to the courthouse. But at this time, then we.
It's already
are in
5
recess.
o'clock, guys. It's like, how do you want to vote? You want to vote guilty? This could be a quick one, guys. Well, I do actually have some late breaking video that's only come to my attention recently regarding this case that wasn't presented in court, which is quite surprising, to be honest. But, I thought we could watch this late breaking video and see if it changes our mind about any of the elements of the case. So we'll just go ahead and watch that real quick.
This morning with a bad hangover, and my penis was missing again. This happens all the time. It's detachable. This comes in handy a lot of the time. I can leave it home when I think it's going to get me in trouble, or I can rent it out when I don't need it. But now and then I go to a party, get drunk, and the next morning I can't, for the life of me, remember what I did with it. First I looked around my apartment and I couldn't find it, so I called up the place where the party was. They hadn't seen it either. I asked them to check the medicine cabinet, because for some reason I leave it there sometimes, but not this time. So I told them if it pops up to let me know. I called a few people who were at the party, but they were no help.
Well, that was a truly surprising video that really brought a whole new light to this testimony, to my mind, and I think to yours as well. Really cut things in a new light, for sure. So, good times. So, yeah. So, yeah, that will kind of conclude our testimony, I suppose, for the day. Yeah. Thank you. I aim for awesome. Me, B-Fish and me. B-Fish is my new producer. B-Fish is my new producer. Hey, Andrew from Legal Mindset. Hey, Andrew. Hey, how you doing, Andrew? I'm a B-Fish. Hey, Andrew, has Andrew seen B-Fish? Has Andrew seen B-Fish, friend? Does Andrew know about B-Fish? Hi, Andrew. I'm a B-Fish. Ha 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 ha. I have a cool hat. And I have a detachable penis. Woo, woo, woo. Okay, great. Why wouldn't they keep holding us for the next phase? That's a good question, actually. Well, I suppose it's because it's the same jurors, right? So, I mean, yeah, I don't know what the deal is with keeping the alternates or not, but yeah, I don't know how that works in this context. I don't know what happens in I don't know what happens if they reach a verdict for guilty, but then deadlock in the next phase. What that means? I don't know exactly what that means. Detachable B-Fish. Yeah. Well, if someone gets ill, I guess you could call him back. I mean, I don't know how that works. Again, I don't know the exact details here when it comes to the relevant state law. Tell Andrew from Legal Mindset I had the name first. Yeah, well, you'll have to fight Bronca for it as well. You know what I mean? What is Mindset doing right now? Let's stream snipe him. What's he talking about?
the above. That's what we do. That's the power of streamception. You don't have to choose. I choose for you, and I choose not to choose. I choose to choose them all. I choose to choose them
insightful.
all. So let's pop over as you guys vote on this as the poll is up. By the way, Kurt winning the poll so far at 42%, but I'm going to leave it up for a while, let more people vote. Let's
cool. I'm
pop
winning a poll over
around
there.
and let's see how everybody else is.
And so we're having a really fun time. Let's see if he pops over here. If he does, I'm going to introduce Andrew to the B-Fish. Yeah, no, I'm gonna, no, we're gonna, no, it's fine. No, damn it, I turned it off so he'd come over here. Damn it, shit, I didn't cut it off fast enough. Shit. He was going to come to me, and then he saw I was streaming him. I couldn't get off fast enough. Damn it. I'm not stacking any ballot box. I don't know anything about a ballot box. I don't know anything about a vote. I don't even know what they're voting on. I just know that apparently I'm winning. Oh, I won best stream of the night in legal mindsets chat. Oh, apparently with 45% of the vote, I'm winning best stream. Excellent. I like it. This is nice. Hey, 40%. I'm winning best stream, man. All right. I'm winning over Nick. I'm winning over Joe. I'm winning over. Hey, I'm feeling good, man. Winning over Vices. Best stream. Kick ass. Huh. And yesterday I won the vote too for most improved stream from the day before. So yesterday I won the vote too for most improved stream, and today I'm winning the vote for best stream. So my fans, I got some fans out there. I'm just waiting to see if Legal Vice. I'm just waiting to see if Mindset will pop over here, because if he does, I'm going to introduce him to B-Fish. Do this. Hey, Andrew. I'm Callie, the B-Fish. I'm Callie, the B-Fish, Andrew. Come over here to the stream. I want to tell you about my honey. Yeah, he is watching Joe. I'm winning with 50% of the vote. I know, it's good shit, man. I'm winning with 50% of the vote. This is nice. No, that's good stuff. No, yeah, I see. Yeah, it's good stuff. I'm listening to them talk. I'm listening to Joe talk, explain reasonable doubt. There's not even a little bit of reasonable doubt. It's not even close. There's not even a scintilla, or as legal bites might say, a chinchilla of reasonable doubt. There is no doubt that is even approaching reasonable in this case. So I don't know what they're talking about. Yeah. She said everything there is to say about it, and all the evidence confirms it. And it's a lot. You want a swoop? We can do a swoop. Yeah, we can do a swoop. Hold on. Yeah. Andrew, check out my channel. Come on. Stream snipe me, jerk. Stream snipe me so I can introduce your audience to the B-Fish. Whoop kicked me out of my own stream, which is nice too. Wow. Joe apparently thinks that Schabusiness killed him. Joe has a based take. This is good stuff. There's always unreasonable doubt. I'm not even sure there's that in this case. I'm not even sure there's unreasonable doubt at this point. A green screen with that background. Oh, that could be fun. Or like projecting like a fish tank or something on there. It could be fun. Yeah. The bee fish is here. I'm 52%. Excellent. I'm very happy about that. I'm happy to have won yesterday's stream of most improved stream. People on yesterday's stream, on Legal Mindset stream, were commenting that I was really happy and commenting that I was in good spirits and commenting that I was happy and commenting that I was in positive and smiling and stuff like that. And it's nice to know that the steps I'm making in my life to try to improve my life and crawl out of this depression hole are working at least a little bit, right? I mean, it's depression. So it's not exactly an on-off thing, but it's nice to know that between the improv classes and leaving my job, which was a huge factor, getting out and taking classes and going to the gym and eating healthier, that I'm making steps that are really beginning to manifest a difference. It's really encouraging. I was in a dark place for a long time, my friends. And and I'm still in a dark place. Let's not be overly cheery about this, okay? Let's not be overly cheery about this. Like, I'm still dealing with depression, so let's not get too ahead of ourselves. And there are days certainly where I'm down, and days where I'm sad, and days where I'm really having trouble. So it is not, let's not be too Pollyanna about the whole thing, but we're heading in a positive direction. And maybe if we're really lucky, we'll crawl out of the hole completely. That'd be nice. Maybe depression will end. I don't know if that's possible, but we'll find out. That'd be exciting. So I'm very excited about all that. Oh, thank you, Melissa, for the nice gift memberships as well. All that good stuff. I appreciate everyone who helps to support the chat. It makes a big difference with everyone that we do. Oh, good. Hello. Hey, Legal Mindset. Hey, Legal Mindset. My name is Callie. I'm a bee fish. The state of California said that bees are a kind of fish for the purposes of the Endangered Species Act. Isn't that super exciting? Andrew, I'm a bee fish. I don't make any sense, much like everything else going on in California. Hello, Legal Mindset chat. It's so nice to see you. I'm Callie the bee fish. I go buzz, buzz, buzz in the ocean. Buzz, buzz, buzz. Swimming around, buzz, buzz, buzz. I'm Callie the bee fish. Callie the bee fish. Yeah, we're having a good time over here, everyone. Having a good time. Yeah, so we're enjoying this entire trial. Oh, man. I love stuff. I love my life sometimes. Life is good. Good times. Well, my friends, I think with that being said, there's nowhere left to go. I think me and Callie both need a workout. I need to work on my lats, and Callie needs to work on his fins / wings so that he can help glide along in this new brave world we're all entering together. I've been on Civil Law. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.